I know, I know.
I'm just so hoping that these are all south over half of
The principal, all of that. But of course, I think it's set for Monday, but I haven't spoken with them.
Well, I don't know which ones are out of custody. It's not very accurate on here. Mine doesn't label anybody as an inmate. Mine doesn't label anyone as an inmate.
If I give you mine.
You just tell me if they're an inmate and I'll pass it. All right, good afternoon, everyone. Sorry I'm just a touch late. But we didn't finish our 9 o'clock docket till about 1 o'clock, so. I'm Judge Oberliesen. This is our felony arraignment docket. What I'm going to do is call up each case by name. I'm going to inform you what you're charged with. The state's going to advise if they have an information filed, and then a copy of that will be given to you, and information is a charging document. And then if you're not represented, I'm going to ask you if you want me to appoint you a public defender. I may have some questions about that. But let's go ahead and get started with Deshaun Fields or Deshaun Fields. He's an inmate? Okay. Alexander Moore. Come on up, sir. This is 25 CF 1991. Do we have an information for him? All right, Mr. Moore, you're charged with battery and grand theft. Mr. Williams, do you represent him? Got your name on it, but it also says self next to it. Sorry, I'm not sure if you're representing yourself or Mr.
No. I applied for a public defender.
Okay.
Judge, I'm just looking, to see if we already have a file on him. Not seeing it, so I'll just go ahead and, okay, you may have, but I've been in court, so I haven't been on my email. Judge, it looks like, yeah, I see it here. Judge, I'll enter a plea of not guilty on his behalf.
Sorry.
Yes, it's a security issue for him. Looks
Don't
like
throw your hands up,
information-
that's what the security needs to be done.
It's, looks like an information has been filed, enter a plea of not guilty on his behalf, and 15 days pre-arraignment motions, trial by jury.
All right, do you want December? That's far enough out.
Judge, I would think so.
Okay. All right, Mr. Moore, your pretrial conference is going to be December 22nd at 1 p.m. Be back on that date. Stay in touch with Mr. Williams. He's your assigned lawyer.
Okay.
Okay? All right, thank you, Mr. Moore. Mr. Moore, you can keep this. This is your copy, okay?
Thank you.
All right. And I got, next is Binford. Is that Marlon Binford? I don't know if he's an inmate. Yeah.
All right, sounds good.
This report says court information has today's date and no time.
It would be a case where it'd be me, if you did appoint the public defender judge as in front of the court, I'd just ask for continuance to the next arraignment, see if he shows up.
How would he know to show up?
I understand.
You don't have any information? You haven't been appointed?
No, Your Honor, no, it would fall within my part of the alphabet, and given he requests an attorney, I would say the same thing.
Address, I guess let's send them a notice to appear for, December 4th for arraignment. right, Santos Brulio. Braulio. That one's been null processed. Okay, that's easy. Oh, that's out of state. All right, Frederick Brown, inmate. Jordan Cook. Is Jordan Cook here? Have the wrong docket. Notice to appear. Oh, that's the bondsman. The bond paperwork has today's date, today's time, and it was signed by Mr. Cook. All right, last call for Jordan Cook. Capias, no bond on Cook. Xavier Fontenot. All right, Mr. Fontenot, you're here in 25 CF 1833, charged with fleeing to elude, DUI, and reckless driving. Can you afford an attorney to represent you?
I don't have one.
You don't have one. Would you like one?
Yes.
Okay. All right, so I'm going to go ahead and provisionally appoint the Public Defender's Office. What you're going to have to do is fill out, do we have applications? All right, fill out that application, Mr. Fontenot, bring it down to the first floor of the clerk's office, turn it in before you leave here today. All right, I'm going to, Mr. Maddox?
Yes,
that
Your
gonna be
Honor.
yours?
I'll go ahead and enter a not guilty plea on his behalf, ask for 15 days for any prior motions and trial by jury. Does the state have an offer, though, at least for his consideration?
No, because I'm trying to verify the prior DUIs. I think, yeah.
No problem.
All right, Mr. Fontenot, you're going to come back on December 22nd at 1 PM. Stay in touch with your lawyer. All right, Tommy Highnote.
Thanks.
Mr. Highnote, you're here 25 CF 1945, charged with driving on a permanently revoked driver's license.
Yes, sir.
Okay. Can you afford an attorney to represent you, Mr. Highnote?
No, sir.
Same thing as the last gentleman. You fill out one of those forms, bring it down to the first floor. I'm going to appoint the Public Defender's Office provisionally.
Be right here.
Jones.
I know.
Okay.
High note, yeah. Judge, Mr. High Note's
Yes, sir.
going to be ours. All right, Mr. High Note. Go ahead and make an appointment with us, and then fill out that application and drop it off at the clerk's office.
All right, first floor clerk's office.
Judge, I'll enter a plea of not guilty on his behalf and request 15 days for pre-arraignment motions.
All right, December 22nd, 1 o'clock, Mr. Highnote. Stay in touch with Mr. Williams. We'll see you back on that day.
Thank you very much, Judge.
All
Okay.
right, Bobby Kane. Bobby Kane here. Do I have anything from an attorney or anything? So you know why Joshua Mitchell is assigned to this case?
Angela Lyles for the state. Joshua Mitchell is my supervisor. He is assigned to this case, and the victim is a state attorney in Okaloosa County. Assistant state.
Do I have any idea if this person's represented? I didn't
saw
see
him.
anything.
No, sir.
All right, thank you, Ms. Lyles. I see that there is bond paperwork with today's date and time via KPS with no bond.
Thank you, Judge.
All right, Thomas Reeves, inmate. Carrie Richburg. Afternoon, Ms. Richburg.
Good afternoon, Judge.
You're here in, let's see, 25 CF 1799. Do we have any information? It was Malprost?
Yeah, it's not here. I think Ms. Rivers was reminding me that I think I was gonna send the case to county court.
Yes. It was the count two that was the issue, and my understanding in speaking with Ms. Leone a couple of weeks ago by email is that she was going to be sending this to county court.
Okay, it was just count 2 is Malprost.
Correct. Yeah, count 1 and count 3 would remain.
Judge, can I speak on my behalf?
Just give me 1 second. I just want to figure everything out for you first.
Yes. Yeah,
Yes.
I got all the evidence in the car. Yes, sir. I didn't know where I needed to turn it into, sir.
Hold on. I don't see a misdemeanor case number yet.
So I had a nice thing of hot tea and I left it downstairs now. It's definitely a kind of cozy, sleepy day. I left maybe some hot tea, so I better run down and go get it right on. Well, it's just a reason.
Weren't you here October 9th?
Yes, yes, she was, Your Honor, and you did appoint the public defender.
Okay.
She'd indicated she didn't need representation, but you did appoint the public defender.
I'll go down
based
there.
on conversations with her.
Sure. So, Ms. Richburg, what's happened is the state dismissed your felony count, which means it'll be sent over to county court, misdemeanor court. Problem is, I don't see that it's been done yet. So you're going to have another court date with a different judge in this building, but I can't tell you when it is because it hasn't been assigned yet.
We'll just keep calling up here, just keep coming
I
back
wouldn't
up
just
here?
keep calling, but I would certainly maybe check back in early next week, call the clerk's office. They're going to have to send something to you to tell you when your court date is, but I would agree with you. You should be proactive and call to make sure that,
And that means that I'm still out on bond right now, correct? Or how does that work? In the judicial system, sir?
yeah, well, you're out on bond on the other 2 cases, but it's ROR, so, right?
Okay,
But just make sure you call in, I would say call in next week, and they should have a court date for you soon. I'm just not sure why it hasn't been done yet, other than it's only been 2 days.
can I go downstairs and see, and then,
You can try, I'm just not sure they're gonna tell you anything yet.
they told me December 22nd, but now that's misdemeanor.
But that's
court.
this court date. That
Okay.
would have been the court date for this case.
Okay. Yes, sir.
All right, so yeah, just give them a call, stay in touch with them, check your mailbox. You're out of a court date, I just don't want to be a situation where the court date happens, no one tells you, but they don't figure that out, and you end up with a warrant for you. As you know, notice when people haven't shown up when I've called their names, I'm looking it up to make sure they were given notice of it before I just say, go arrest them.
Yes,
But
sir.
just make sure you follow up.
Yes, sir, I will.
All right, thank
Always.
you, Ms.
I'm fine.
Richburg.
God bless y'all.
Yep, Brandon Schneider. Information on him? Ms. Leone?
Yes, Your Honor, I'm aware that there was another defendant with the last name Schneider. Apparently, that information for Michael Schneider
This is
was,
Brandon.
I understand. I said that there has been a confusion, and I was just now texting my assistant to see if she has the correct information, she can file it, or...
The information filed in his case is just from another case. Just happens to have the same last name. Charge is different, case number is different. All right, Mr. Steiner, can you take a seat for us real quick? I just want to get this straightened out, because maybe I can have you avoid coming a second time for this particular type of court date.
Yes, sir.
All right, take a seat, we'll call you back up. All right, Eric Thompson,
He's an inmate.
inmate. Nicholas Wallace, all an inmate. Brian's an inmate. Fell's an inmate. Why are Brian and Fell on the arraignment docket? Cooper's not, you said?
No, Your Honor, I have Jeremy Cooper.
All right, Jeremy Cooper.
Cooper?
Your Honor, informations are filed in all my cases. I've checked.
Okay.
Mr. Cooper. Killing me with that shirt.
What did you
25
say?
CF, I said he's killing me with that shirt. 25 CF 1814.
I'm not allowed to say stuff like that.
25 CF 1814, Your Honor. Still, we're good. Information's been filed previously on 10-9. We had him come for that purpose today, so it has been filed, Your Honor. Once your plea of not guilty, 15 days for any pre-arraignment motions, trial by jury. He is set for pretrial conference in December the 22nd. I just ask that be left.
Okay, Mr. Cooper, it's going to be December 22nd at 1 PM. We'll see you back on that date. Stay in touch with Mr. Maddox. David Demers.
All right, this is Mr. David Demers before the court in 25 CF 1789. Information's been filed, Your Honor. Pretrial conference set for December 22nd. We'd ask for, or we'd enter a not guilty plea, 15 days for any pre-arraignment motions, trial by jury, Your Honor.
All right, it's going to be December 22nd at 1 PM.
Thank you. Bruce Durham,
Bruce Durham.
President approaching, Your Honor. He's before the court in 25 CF 1918. Information has been filed, Your Honor. Pretrial conference set for December 22nd. We'd enter a not guilty plea at this time. Ask for 15 days for any pre-arraignment motions and trial by jury.
Mr. Durham, it's going to be December 22nd, 1 o'clock for your pretrial conference. Stay in touch with Mr. Maddox, and we'll see you back on that date.
Thank you, sir.
Luis Fonseca. Oh, okay, let's just take him then.
Mr. Fonseca. All right. Your Honor, this is Mr. Fonseca before the court in 25 CF 1972. Information has been filed. Pretrial conference set for December 22nd. Your Honor, we'd enter a not guilty plea at this time. 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Fonseca, you'll be December 23rd at 9 o'clock.
Apologies.
Due to the fact that you're in custody.
Yes, Your
That'll be your
Honor.
next court date.
All right.
Right. Nicole Guerra.
We have Destiny Fryox before that.
I don't mind.
Destiny Froix, 25 CF 1898, also set for today, or at least according to my file. This is Miss
Right,
Swift.
yeah, okay.
For you.
Yes, sir. Yes, sir. I just wanted to ask the judge.
I see that case, but when I look it up and it's not on my docket, we'll take a look at it. No.
All right, I'll take a look as well, Your Honor. Thank you. This is Nicole Guerra, Your Honor, before the court in 25 CF 1763. Information has been filed, Your Honor.
Hold on a second. What is your name, ma'am?
For you.
I said Guerra.
Oh, I'm so sorry, I thought.
Okay, hold on a second. Wait.
Yeah, this
Let's
is me
give her
right
the
here.
proper info. She's already here. Miss Guerra, we'll call you up next. Let's just,
That's my bad.
all right. Information, do we have, how do you pronounce the last name?
For you.
For you. You have information from Miss For You?
I see an information file.
Information has been filed.
Yes, Your Honor.
We'll get you a copy of that, but this is 25 CF 1898. Information shows charges of false imprisonment and misdemeanor battery.
Yes, Your Honor.
Go ahead.
Your Honor, we'd enter plea of not guilty at this time. Ask for 15 days for any prior motions and trial by jury.
All right. Ms. For You, you're going to come back on December 22nd, 1 o'clock. Stay in touch with your lawyer.
Sorry about that, ma'am.
All right, now Ms. Guerra.
All right, sorry about that, Your Honor.
No, I thought you were the one that wasn't getting things on the docket properly. I'd blame you. It's clearly not the case.
I thought she said she was Miss Guerra. You're Miss Guerra, correct?
Yes.
Okay, yes? All right.
Okay. 25 CF 1763.
Yes, Your Honor. Information filed, Your Honor. Pretrial conference set for December 22nd. We'd enter a not guilty plea at this time. Ask for 15 days for any prior motions and trial by jury.
Going to be December 22nd, 1 PM for your pretrial conference. Stay in touch with your lawyer. Be back on that day.
All right, thank you, Your Honor. And that should be all my out of custodies.
All right. James LeBron. This is Ms. Rivers. I have you listed for this one.
No, Your Honor, this would be Mr. Williams' case.
We've gone back to a purely.
I mean, I might as well just flip a
Judge.
coin sometime.
Judge, this is James LeBron, case number 25-1955. I was showing that an information had been filed. Looks like he's just been handed one. I'll enter plea of not guilty on his behalf. Request 15 days for pre-arraignment motions and trial by jury.
December 23rd, 9 o'clock for pretrial conference.
Thank you, Judge.
All right. Ryan Peterson.
All right, Mr. LeBron.
Rivers.
Yes, Your Honor. He's before the court on 25 CF 1926. Is there an information?
Witness successfully proved.
Leone? Any idea on
It
information on
says child
Peterson?
neglect, so it would be Ms. Fosse.
Oh, is there, okay. Ms. Basso or Ms. Berrickman, do y'all have
Peterson,
Ryan
you said?
Peterson?
Yes.
We haven't, I don't believe we filed it yet.
That was the one that.
Right,
There was a
that-
mix-up on it.
It's coming to the division, Your Honor. It's not going to be handled by the CAC, and I have not filed the information yet.
This was one of those, it was some mix-up with the clerk and the transfers and everything,
All right.
but. we
So
brought it-
information hasn't been filed.
got it now.
So, is the court going to continue
I'll
the?
continue the arraignment. I think you can have it done for next week.
Yes, Your Honor.
All right. Mr. Peterson, I'm going to give you a court date next week. It's November 6th at 1:30 for your arraignment, and they'll have your information filed by then. Thank you. Jordis Reed.
Your Honor, this is Jordis Reed on 25 CF 1896. We're going to enter not guilty plea, request trial by jury.
All right, December 22nd, 1 o'clock for your pretrial conference. Jared Riley.
We handled him this morning, Your Honor.
Oh, that's right.
And we also handled Ashley
Ashley
Roberts
Roberts.
this morning,
I've written it down and I just breezed right through it.
John Saber this morning.
They were this morning. Juliet Sexton.
Your Honor, she's went to drug court.
She's in drug court?
She's supposed to have pled out yesterday. I met with her on Tuesday and the drug court lady, and she was pleading out yesterday.
I can't see the plea and sentencing agreement, but it was filed yesterday. Here it is. Went into drug court yesterday. Jeffrey Smiley.
Your Honor, Mr. Smiley's before the court on 25 CF 1843. We're going to enter a not guilty plea and request trial by jury.
December 22nd, 1 p.m. is your pretrial conference date. Mr. Smiley, be back on that date.
Thank you.
All right, Craig Swinarski.
Okay.
Come on up, sir. Craig Swinarski, 25 CF 1825.
Your Honor, we're going to enter a not
Information's been
guilty
filed.
plea and request trial by jury.
All right, Mr. Swinarski, it's going to be December 22nd, 1 p.m.
Yes, sir.
See you back on that day. Derek Tolar, and he's an inmate.
Also known to me since they were young.
Your Honor, we're going to enter a denial, if we haven't already, on 24 CF 1990, which, actually, that one's supposed to be yours, and that's listed as mine. We're going to enter a not guilty on 25 CF 1800.
And what the situation with Mr. Tolar, Your Honor, we've been working with the South End with Mr. Gomez to get Mr. Tolar in drug court. I talked with Mr. Gomez yesterday. I would expect Mr. Tolar no later than 2 weeks from yesterday to be in drug court. The timeline I've given, if we can make it happen next week, we certainly will. But we've been trying to get him in a drug court for a couple of weeks now.
Well, I'll give him a control date for us of December 23rd, 9 o'clock. All right. Gary Wright.
Your Honor, he was handed a copy of the information, so we're going to enter a not guilty plea and ask for the 12/22 court date.
12/22 at 1 o'clock. Mr. Wright, we'll see you back then.
Sir.
That was 25 CF 1812. Slater Cole. Oh, I just found Destiny for you. She's under Jay Williams. Who would have Cole? It says Jay Williams, but
It would
That
be
would be
Landon, Judge.
Mr. Maddox.
I'll stand in for him.
I'd be wrong so often.
Judge, have we been appointed on Mr. Cole? Okay, in that case,
Yeah,
let me
Mr.
see the
Maddox filed a
information
notice of
real quick.
appearance, but it's still showing your name on it, Mr. Williams.
All right, Judge. Judge, he's got a copy of the information. I'll enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, trial by jury.
Mr. Cole, your pretrial conference date's going to be December 23rd, 9 o'clock.
What's going on?
We said that you didn't do this, and so your next court date will be December 23rd, and Mr. Maddox will come out
Is
to
there
the
any
jail
way
and
I
see
can
you.
just plead no contest and plead out to the mercy of the court right now?
Well, it's a felony. I can give you up to 5 years prison if you do that.
Right, well, I'll plead out to you, Honorable Judge David.
All right, well, that's not the proper title, but also, I don't know anything about you, Mr. Cole, so I'd have to set it off for a sentencing if you were to do that.
Okay.
Mr.
that'd be
Maddox, this
great.
is actually your case.
Yes, sir.
Mr. Cole.
Hey, how are you doing today, sir?
Does the state have an offer for his consideration?
Yeah, it was gonna be 11/29,
OCJ, does he score?
tell you in a second.
I'll certainly talk to him about that for a few minutes before.
He does not score,
What does he score then? What's his points?
35 points.
I mean, is it,
Let me do this, Your Honor. Let me pass him. Let me talk to the state some more about it. Let me see if we can work out. Let me talk to Mr. Cole first and make sure there's no concerns. And if there aren't, then let me talk to the state and see if we can work something out, Your Honor, if we could pass him.
All right, let's pass Mr. Cole.
okay.
All right, Jeremiah Hamilton.
Thank you, Honorable Judge, thank you.
All right. Thank you, Your Honor.
I mean, it's better than Mr. like I kept getting yesterday. All right, are you Mr. Hamilton?
Yes, sir.
All right, Mr. Williams is your public defender right behind you.
Judge Jay Williams from Mr. Hamilton. I checked, I guess yesterday, and an information had been filed. I'll enter a plea of not guilty on his behalf, 15 days of pre-arraignment motions and trial by jury, unless the state's got an offer today.
It's just 2 years of probation, plead as charged. He has prior felonies.
So, sir, it would be a felony, but you plead to all of these, no contest, but it would be 2 years of probation total. Do you want to do that, or you want to turn it off? So, Judge,
All right, Mr. Hamilton, we'll see you back on 12/22, 1 o'clock.
Yes, sir. Thank you.
All right, thank you.
hang on, sir.
David Hargraves.
Judge, Mr. Hargraves is mine as well.
25 CF 1811. Information's been handed to Mr. Hargraves. What would you like to do,
Okay.
Mr. Williams?
Judge, I'm going to plea not guilty on his behalf. At the time that I checked it, we didn't have an info, and then it looks like I found one yesterday.
All right, Mr. Hargraves, we'll see you back for your pretrial conference. It's going to be December 23rd at 9 o'clock.
And, sir, at least as of the 22nd, we still didn't have discovery on you. When I get that, though, and if there's an offer in it, I'll go over the offer. Otherwise, I'll just make you aware of what's in discovery. If you want a copy of it, you just need to let me know.
So the offer is for 3 years of probation with some conditions.
The state's just tendered an offer to you. Whether or not to take an offer is up to you. It's not up to me. If you want to take that offer of 3 years probation, I can draft it up for you, talk with you, and bring it back out, and you can take it.
Yes.
You want to do that?
Yes, sir.
All right, well, we'll do that then. I'll draft it up for him, Judge.
All right, Mr. Hargraves, we'll bring you back in a little bit. He's going to draft up that paperwork for you, and we'll readdress it today. All right, Henry Jackson, 25 CF 1754.
Yes, sir, Judge. This is Henry Jackson. Does the state have an offer on Mr. Jackson?
1 second, let me access Henry Jackson, yeah. He's got a 3-year min and 60 months DOC.
All right, Judge, I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions and trial by jury.
And Mr. Jackson, we'll see you back on December 23rd, 9 o'clock. Anthony McLeod, 25 CF 1967. Oh, also 25 CF 1978 and 1990.
Is there a 1967?
That's the first one I said.
Oh, I'm sorry.
And I turned the page and realized there was 2 more.
Does the state have an offer to resolve all 3?
1 second. Yes, 50 months DOC.
Unless you want to do that, sir, I'm going to suggest that I enter a plea of not guilty on your behalf, and I'll come out and see you.
All right.
All right, so Judge, I'll enter a plea of not guilty on his behalf, 15 days for pre-arraignment motions, trial by jury.
All right, December 23rd, 9 o'clock.
Thank you, Judge.
Want me to start back at the top, or how you doing that? Okay, I'm just going to run through the top of the docket again. Deshaun Fields. All right, it's 25 CF 1946, Mr. Maddox.
Yes, Your Honor. Information has been filed, Your Honor. At this time, we'd enter a plea of not guilty, ask for 15 days for any pre-arraignment motions and trial by jury. The December date is set, Your Honor, to be December 23rd.
All right, December 23rd, 9 a.m. for your pretrial conference, Mr. Fields. I think we did more.
And then, Your Honor, I did have a couple that I talked to in the gallery that showed up from earlier, whenever you want to call them back up.
All right, thank you, Mr. Fields.
All right, thank you, sir.
All right, Frederick Brown. Ever hear anything about Mr. Brown? Is he an inmate? Okay. Thomas Reeves, so we don't have any inmates. Any ready chambered? Ms. Leone, did you figure out the Schneider situation yet?
Yeah, it was just filed, Your Honor. We had not filed it before. I have a copy if I can go grab it.
Oh, you have one?
Yes, we prepared it while this was going on. It's been e-filed, and I have a copy that I
Okay.
can grab, if you don't
Why don't you
mind.
grab that, because that way we can get
Yes, sir.
Mr. Schneider to not have to come back. Brown, Frederick Brown? Do you have information for Mr. Brown? All right, Mr. Brown, you're here in 25 CF 1949.
Sorry. Hold it.
I'll get it.
You're charged with tampering with fire equipment, which is a third-degree felony. Do you understand that?
That wasn't, is that supposed to be in my cell?
I'm not sure what you're referring to, but don't talk about the facts of your case. It can be used
Okay,
against you.
my bad, because, you know,
I'm
that
gonna
was
go ahead and appoint the public
only cell
defender.
with
Yes,
that
Your Honor.
type of sprinkler.
Mr. Brown, hold on. Your Honor, I've spoken with Mr. Brown. He understands the charges, at least at this time. Your Honor, went to a plea of not guilty. Asked for 15 days for any pre-arraignment motions and trial by jury. Does the state have an offer in the meantime for his consideration?
He's got 2 other cases in the south end.
Oh, okay.
Oh, okay. Yeah.
Those two, sir, okay.
So he's set for, I'm assuming the state's going to send this down.
With the other ones, yes.
So it'll be transferred, sir, so you
So
get determined.
let's just put it on December 10th at 9 o'clock. Hold on, let me check that date. Yes, December 10th at 9 o'clock in front of Judge Clark.
All right, thank you, Your Honor. This is for you, you can keep that.
Have a blessed day.
All right, thank you, sir. Thank you, Your Honor.
You have Reeves? Okay, gotcha. All right. Mr. Mattis, you say there's some people that you've talked to that maybe came in late?
Yes, Your Honor, Mr. Benford and Mr. Cook.
All right, Benford. Good afternoon, Mr. Benford. You're here in 25 CF 1920. Do we have any information for him? Someone tell you the time to be here? Your
Yes,
paperwork
sir.
didn't have it. That's why I was going to have them send you a notice to appear.
Yes, sir. My bail bondsman, Mr. Clem, they gave me a call and let me know. And I also called the clerk of
Okay.
courts and was like, hey, I need to know what's going on. I never got a date or anything like that.
Well, there was a date on your paperwork, but no time.
That's what I mean. So I was like, I don't know what I'm doing
So
here.
usually when someone doesn't show up or even late, we put a warrant out for them, but because we realized that, I was just going to send mail to your house. I'm glad that you're here and can
Yes, sir.
take care of your case today. Mr. Benford, can you afford a lawyer to represent you?
No.
Okay. I'm going to go ahead and provisionally appoint the public defender's office to you, but you've got to fill out that application. Should be the one right there in front of you.
All right.
Turn that into the clerk's office on the first floor before you leave today.
10-4.
Your Honor, went to a plea of not guilty today. Asked for 15 days for any pre-arraignment motions and trial by jury.
All right, Mr. Benford, this is Mr. Maddox. He's going to be your lawyer. Stay in touch with him. I'm going to give you a court date of December 22nd at 1 p.m.
All right.
All right.
Thank you.
All right.
And who was the
Gordon
other?
Cook, Your Honor. I've
Cook.
represented him before.
Okay.
I knew the name sounded familiar. I just didn't know if he was or not. Your Honor, I would ask to be appointed based on our previous appointments to his cases.
Draw the KPS on Mr. Cook. Appoint the public defender. Mr. Cook, you're going to have to fill out one of those applications, turn it in on the first floor downstairs before you leave here today. Your next court date's going to be December 22nd at 1 p.m.
All right. And we do enter a plea of not guilty just for record purposes, Your Honor. I'll take it from you out there. Yeah, that's fine. I'll come grab it from you. Yep, just wait for me out there for a few minutes. Thank you, Your Honor.
Good one. That's the information. Oh,
I thought that's what you handed him. My apologies.
Your Honor, that gentleman in the back, remember there was a mix-up with the information?
Snyder. Well, I asked Ms. Leone, she went to go get the paperwork. All right, Mr. Schneider, come back up.
The information.
Sure. I'll give it to the clerk, but let me take a look at it real quick. I don't need a copy if
For
it's.
Mr. Schneider?
Yes. All right, Mr. Schneider. You're here in 25 CF 1786, charged with possession of a controlled substance, which is a third-degree felony. Information's been filed and given to Mr. Schneider.
Your Honor, may we have a moment?
Sure.
The,
I've got more in my office, I forgot to take.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
It's going to be December 22nd, 1 PM for your next court date, Mr. Schneider. We'll see you back on that date. All right, anybody else in the audience who thinks they have a case on the docket? Miss, your name?
Hardy, Gracie Hardy.
Wait, say again?
Hardy, Gracie Hardy.
Hardy? Hardy?
Judge, I have her on the docket that I pulled earlier, and I've got a file on it.
Okay. Come on up, Miss Hardy.
Go ahead, Ms. Hardy. Judge, it looks like an information has been filed. Does the state have an offer on it? Yeah, it's a possession of fentanyl.
I don't know. Could you spell the last name, Mr. Williams?
Hardy.
Okay, let me check. I don't have it in my paper files, but I can check over here.
There's an information file. It says Joshua Sheep, but I'm pretty sure that's not his signature or yours.
Yeah, it's, I can't read the signature. I can read the bar number, but I can't read the signature.
Oh, yeah, it's not mine. It's right. I have no idea.
All right, Judge, I think,
The bar number, I'll look.
then I'm just going to enter a plea of not.
But let me check.
Get over near mine.
Gracie.
Let me ask.
Ms. Herndon's signature.
Is it? I
Judge,
mean, could be.
No, her bar number is written into it. I looked it up by bar number.
Oh.
all right, Judge, I've talked with the client briefly. She preferred to come in and talk with me about the case, so I'm going to enter a plea of not guilty on her behalf, request 15 days for pre-arraignment motions and trial by jury.
The offer was for 24 months of probation.
All right, Ms. Hardy, your next court date's going to be December 22nd at 1 PM.
okay, yes, sir.
All right, ma'am. I'm going to give you a card. You need to make an appointment, come in and see me, okay? That's for you.
Thank you.
I think the issue, Ms. Leone, is your name's not on it either. Both attorney sections are just blank, in my system at least.
Sam.
So it means we probably didn't do a notice of appearance.
Notice of appearance.
There isn't one, yeah. Not that I can see.
I'll ask for that to be filed.
All right, what was the name?
Call this number. Come see me,
All right, come on up, ma'am. Were you late?
Yes, I'm
Okay.
sorry.
So,
I don't have a license.
I understand, it's just,
I'm so sorry.
no, there's a warrant for you right now.
Oh.
I'm going to withdraw it because now you're here. All right, can you afford an attorney to represent you in this case?
Considering who the other party was in this case, I've been out trying to find an attorney, but they've had conflicts of interest. So I'm asking for a continuance right now so I can.
Well, do you want me to appoint you a public defender?
I think I need more than a public defender for this case, but can I get a public defender and then still go find another?
You can always change.
Okay, that's what I was asking, yeah. Then that would be fine for me right
All right,
now.
I'm going to have you fill out the application first.
Okay.
You want to have her fill it out before the court makes a,
I'll provisionally appoint the public defender, but you have to fill that out and turn it in this afternoon down on the first floor at the clerk's office.
Okay.
ma'am, what's your name?
Bobby Kane, Kane, K.
I've already made you on my list. All right, K-E-E.
Kane.
Kane. All right, Judge, what I'm going to do is I'm going to enter a plea of not guilty on Ms. Kane's behalf, request 15 days for pre-arraignment motions and trial by jury.
All right, Ms. Kane, we'll see you back on December 22nd at 1 o'clock.
Thank you, Your Honor.
Ms. Kane, I'm going to give you a card. Call the number on that card and make an appointment to come see me, okay? All right,
Thank you very much.
All right, did we have anyone else? Do you have people? Oh, geez. All right, you Thomas Reeves?
Yes, sir.
All right, Mr. Reeves, 25 CF 1741. We have information. Like you're charged with battery by a person detained in a jail facility. Do you have a case here or in the south end?
Are you asking me if I have?
Yes. Do you have another case pending?
I have a case pending in Fort Walton.
Okay, that's what I'm trying to figure out.
But we did want to keep this separate. I spoke with my paid attorney for the Fort Walton cases. I'm not going to be able to hire him for this case in particular.
Well, I understand, but we typically put the cases together for purpose of having you in front of one judge with one prosecutor, one defense lawyer, if they're appointed. That way you're not coming to two different court dates in two different divisions. So that doesn't mean your paid attorney has to do this one, but,
No, I mean, he recommended that I keep it separate.
well, the state files that motion, so they get to make that choice. And because you're saying you can't afford a lawyer for this case, do you want me to appoint you a public defender?
Yes, sir.
Want the public defender for Mr. Reeves. State gonna transfer the case? He's got a pending case in front of Judge Stone.
Yes, sir.
All right, so I'm just going to give you that court date. Otherwise, you're going to have to come up here just for me to tell you it's going to go down south. So it's going to be November 10th at 9 o'clock. And that's going to, well, hold on. You're in custody. It'll be November 12th at 9 o'clock. Be in front of Judge Stone.
Sir.
Okay.
Thompson.
All right, are you Eric Thompson? All right, Mr. Thompson, you're here in 25 CF 1831. You have an information handed. I'm going to go ahead and appoint the public defender for you, Mr. Thompson.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
On December 23rd, 9 o'clock for pretrial. All right. Nicholas Wallace, you're here 25 CF 1818. Information's been handed to him.
Your Honor, we're going to enter a not guilty plea and request trial by jury, and we're going to ask to put his case on the 1223 docket.
Wallace, you're going to be on December 23rd at 9 o'clock.
believe is pretty good. However, based on conversations I've had with him, how he wants to proceed and what arguments he wants to make, I think I need to kind of beef it up with my own motion. So I will get that motion written and filed, hopefully by the 15th of November. So if we could just put this on for 12/4.
Is this the attempt situation?
It is, it is. And I've read the court's order previously on the other case that you've talked about. I've provided that to Ms. Barrickman. But given what I know Mr. Fell what he wants to argue, I think I need to flesh out that motion.
Do you understand that, Mr. Fell?
Yes, sir.
All right. What date do you want to put the 12/4?
12/4.
All right. 12/4 at 2 o'clock.
That's all I have, if I may be excused.
Yes, Mr. Klein. Oh, what about Christopher Klein?
Has there already been a denial? Has there already been a denial entered from Mr.
It's
Klein?
this morning, right? All right. Looks like your office filed a plea of not guilty and demand for discovery.
I've met with him at the jail, so I've already talked to him. So if we can just put him on a future court.
It's a VOP?
That's my understanding, it's just
Okay,
a.
let's put it for 12/4 at 9.
12/4 at 9, okay. All right.
All right, thank you, Mr. Kleins.
Yeah, they don't put just attempting, not the element that goes with it. Yeah. It stays there, even on the clerk's side.
What do we have left on the 2 o'clock dock? I think everyone's going to continue.
Yeah, I write it behind it. I usually write it down to attempt and then, they'll check the box. Yeah, that's nothing else.
If I can
We've already
inquire, I've
continued
got a couple
Osborne,
that
right? That
are
was
still on
yesterday
the
'cause he
docket.
wasn't
There's-
feeling well.
So what do we have left?
Could be for arraignment.
Ms. Rivers, that's yours, right? Osborne, that's the one we continue because your client was under the weather.
Yes, Your Honor, I did file a notice of cancellation of hearing.
Mr. Williams, do you think we need to handle Mr. Norris?
I'm her.
Ms. Claus here, okay, you're here, okay, on Norris?
I'm Miss Ashley today.
Oh, okay, okay. Judge, I don't know why we couldn't go ahead and do Mr. Norris.
Bring up Mr. Norris. I think it's just rescheduling at this point, right?
It is, it's just to reschedule the date. Just give me a second to pull up the email with Dr. Zeman's availability.
I think that's a concern.
Unfortunately, it's now going to require me to log in again. Of course.
Afternoon, Mr. Norris.
Hey, Mr. Norris, I'm pulling up Dr. Zeman's email real quick so that I know when he's available. Yeah, I've got a whole bunch of everything in there.
What's that? You did? Oh, there's two more coming? Sometimes I can bring it too if I need to. I don't have much left either. I have just the indenture. It's Connor. I always want to call it Robert. It's Connor. Robert.
All right, here we go, Judge. All right, Judge, so Dr. Zeman provided that he was available November 20th, December 4th, December 5th, and December 18th.
And you're
I
on
think
the
we've
Miss
been
Mar-
setting some cases on the 4th, so I know that one's available. The 5th, I thought was available, but I found out that that's not supposed to be available.
Well, the problem is we've also set a few evidentiary type lengthy hearings possibly for the 4th in the afternoon, so I'm worried about putting them there and us running out of time.
Your Honor, Ms. Herndon did indicate she'd be available either the 4th or the 18th.
18th
I
of,
think that was the other date that you all had. Was one.
20th, 4th, 5th, and 18th. I don't know if
all
there's.
right, can I get a month on all of these?
Oh, I'm sorry, Judge. November 20th, and in December, 4th, 5th, and 18th.
I can't do the 18th. I'm not sure why we gave you that date, because that's my civil trial week, and I know I've got at least 2 that are still set.
These aren't.
We can
dates
do the 4th. I was just trying not to overbook the 4th.
These aren't dates that you gave me, Judge. I'm reading
Oh.
the dates that Dr. Zeman.
Okay. Yeah, I'm pretty sure I'm going to be in a civil trial that entire week with the 18th is the Thursday, so I can't do that. All right, let's just do December 4th at 2 o'clock for purposes of that sentencing.
All right, Judge.
Do you have a report from him at this point?
I do, Judge, and we sent it over.
Did you? Okay.
I believe, Ms. Clow, are you available?
Yes, sir.
Okay. So, December 4th at 2 PM then. All right, Mr.
We'll
Reese.
see you back on that date, Mr. Norris.
I'm sorry, I thought I heard somebody.
Who are the
Go
witnesses
ahead and do
for?
him. I forgot.
Your Honor, I do have one witness on Travis Stone's violation of probation hearing, and I believe there might be a second one of those as well, but it's not mine.
And we've got a violation of probation on,
Jones?
yeah, Nathaniel Paul Jones. Ms. Smith? Hey, okay. We were.
I want to decide on who you want to do first, or?
Well, I've got some pleas available as well, except.
I'd like to get the witnesses going.
Yes, sir. If you'll give me a moment with Ms.
These are from this
Smith.
morning.
His file. With your witnesses. It's a violation. It's just a violation of probation. Yeah, you're fine.
I'm okay.
Yeah.
And Mr. Maddox, who's the Harriet Ash? Okay. Go ahead. No, she's not here.
Yeah, no, that's fine. Yeah.
Civil all day. Well, at least most of the day.
I guess I never called David Smith.
Do it Monday. And just,
It's so cold.
who's on that case? Sorry. Why don't y'all talk about it? Here. Yeah, well, give her copy if y'all want to talk about it while I'm handling other things, and then see if we can't figure something out.
Oh.
Yeah. All right. Who are we doing first, Stone or Jones?
I'll go. Stone? You don't know which one's mine, though. Judge, I'll, Travis Stone, please. If Ms. Rivers is ready, that's hers.
All right, that's fine. I just,
Yeah.
I want to get some momentum
we
this
got some
afternoon.
deadlines.
We didn't have a whole lot this morning, so.
Let's get done.
Mr. Williams, are you gonna recall anybody from this morning? Are they gonna be pleas or
I've got
continuances?
two, Mr. Johnson, and then from this morning,
Hamilton?
That's why I wanna
Mr.
do
Johnson from this morning and Mr. McDonald. And I've gone over both of those plea offers
Oh,
with
okay.
them.
Yeah, 'cause I've
They're
already forgot about
prepared to
Oh, I
execute
had them
them.
sitting right here.
Mr. Johnson's,
So I just don't-
we
he
did
doesn't
track
have
down
downtime.
Yeah.
the situation with
He's up.
how he gets to the Master's Touch facility, and he's got to provide his own transportation, but he indicated to my investigator when she talked with him about that he had somebody available. I've talked with the state. We're going to word it as he's to turn himself in there within 24 hours of release. Oh, sorry.
Come out and handle them.
It's David Smith. Isn't it? It is David Smith, isn't it? Probably. John's confused by this.
Why is that? Oh, this is
Just wanted to.
different. They say a violation 13 hours before
It should be David Smith.
drop form was signed.
So I don't know who that is. Yeah, you're right, yeah.
The other one I done with, that's what I went on.
Ms. Rivers, who do we have?
Your Honor, this is John Smith.
Yeah, and
He says this is he thinks he has a new law in front of you.
John Steven Smith?
Yes, sir.
oh, okay, then this is not my.
No, you're good. We have a couple of Smiths here, so we're trying to get it straight.
So I knew.
It should be a
Yes, there's somebody really named John Smith.
restraining order.
He believes it's a violation of a restraining order.
Wrong courtroom.
On my paper docket, but it's not in my.
DOP also? Okay.
That's what it would be. The VOP for that.
Yes.
Because that's misdemeanor. I went to court on the
I got you.
misdemeanor. Yeah.
I understand.
I'm sorry.
So would it
I'm
be a
sorry.
misdemeanor VOP?
No, it's a felony VOP.
Because
or a
I'm
misdemeanor
felony
charge.
probation.
Oh, okay. So then that case, Your Honor, would be 24 CF 258. No, you're fine. You're fine. We're
All right, so
figuring
it's
it
just the
out.
VOP. All right.
So, Your Honor, we will enter a denial.
All right, 12/4 at 9 o'clock.
I'll make it back out there to see you. They have Byron Cotton listed as your attorney. Your Honor, this is David Smith. He was on the docket this morning. Apparently, they brought a different Mr. Smith.
They're all Mr. Smith. Yesterday, we had 4 McDonald's. Yeah, a lot of carpenters. All right, David Aaron Smith?
Sir.
Okay, 21 CF 590.
Your Honor, I am, I spoke with Ms. Basso trying to get a document that he had requested. She was unable to find it. I'm still trying to find one more person that he has requested, so we are requesting one more continuance.
12/4, 9 o'clock.
Thank you, Your Honor.
Thank you.
As far as I know.
Mr. Rick, he'll need to sit down. This is a contested hearing.
All right, this is Travis Scott Stone, 24 CF 2274. We're here for a VOP evidentiary. Is everyone ready to proceed?
Yes, Your Honor.
Do we have any witnesses?
Yes, Your Honor.
How many?
I just have one.
You have one. Do you have any witnesses, Ms. Rivers?
Possibly my client, Your Honor.
Okay, just for sequestration purposes. All right, Ms. Basso, are you ready to go forward with
Yes.
your first witness?
And would you prefer me to come up there?
It's better.
Yeah, we would call Mr. Connor Roberts, please.
Honor Roberts?
Your Honor, he stepped out to use the restroom.
Oh,
He will be right back. He just stepped out.
turned around and he disappeared.
Close but no cigar, Your Honor.
Go away.
That's just our luck.
Yeah.
Yes, I do. Have it in front of me.
Your Honor, there was a third addendum filed. It's been filed for a while, but I just want to check out that Ms. Rivers is on the same page as I was.
Okay. I think your witness is fine.
Yes, he is back. Mr. Roberts, if you'd like to join us when you're ready.
Thank you, sir.
Catherine, if you raise your right hand, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Make sure you speak into that microphone so we can all hear you, okay?
Right.
Go ahead, Ms. Bosson.
Thank you, Your Honor. Good afternoon, Mr. Roberts. Would you please state your full name?
Connor Bryce Nicholas Roberts,
And sir, by whom are you employed?
Florida Department of Corrections.
How long have you been with them?
I've been employed since March of 2021.
What are your basic duties in that job?
I'm a correctional probation specialist, which entails supervising individuals sentenced to community supervision.
As part of your duties as a probation specialist, did you have an opportunity to come in contact with the Travis Scott Stone?
Yes, ma'am, I did.
And how is it that you came into contact with him?
I supervised Mr. Stone while he was on community control.
Okay. And do you see Mr. Stone in the courtroom today?
I do not. Or I do, I'm sorry, he's sitting down, but he was standing up. He's sitting down, he's wearing a green jumpsuit.
Thank you. And ask the record to reflect that he has identified the defendant, Mr. Stone.
I'll just point out there's kind of a monitor in the way as well, so.
Yeah. All right. And Mr. Roberts.
I'm sorry, let the record reflect he's identified the defendant.
Thank you, Ron. And Mr. Roberts, you said you had an opportunity to supervise Mr. Stone. Did you have an opportunity to advise him of the rules of the community control that he was on?
Yes, I instructed Mr. Stone on my personal community control guidelines, of which he signed and stating he understood.
And to your knowledge, had he been previously also advised of all the guidelines, not only yours, but all the guidelines that govern his behavior?
Yes, ma'am. He was instructed on his conditions of community control either 2 or 3 times.
And in your interaction with him, did he appear to understand those guidelines?
Yes, ma'am, he did.
Now, has he been in compliance with those guidelines?
No, he has not.
Could you please kind of walk us through how he has not complied?
While he was still in Pensacola, he was initially, of course, he was sentenced in Okaloosa County. He was transferred to Pensacola to a REAP house, which is Ranch Reliance, Pensacola. After a short while, he was removed from the program and then sent to Master's Touch, which is another reentry program in Pensacola. Not sure on the time frame. He was also removed from Master's Touch and was homeless for a brief period of time in Pensacola. During that time, he failed to keep his electronic monitoring device charged, as well as remain close to his electronic monitoring device, also known as RTC device, thereby causing bracelet battery alarms and bracelet gone alarms. Mr. Stone was subsequently transferred to Okaloosa County as he was homeless and transferred to my supervision on July 1st, 2025. While with me, he was homeless for a brief period of time. I will admit he showed a very strong perseverance despite being homeless during that period of time. However, on July the 31st, he called in to get permission to go to Tractor Supply in the scrapyard in Baker, Florida. He spoke with Senior Supervisor Jernigan, who is my supervisor. She denied the permission. Mr. Stone went to the scrapyard anyways, as reflected by his electronic monitoring points. Then he also had a positive urinalysis, which was observed and screened by myself in August of 2025. Mr. Stone lied about whether or not he had consumed methamphetamine. He did admit that he had used while he was in Pensacola that day. The next day, he then admitted that to consuming methamphetamine, and of course, it was the sample was received by Lear Toxicology, and they reported that it had screened positive or tested positive for the presence of amphetamine and methamphetamine.
And did you in fact document that drug test
Yes, I did.
and the confirmation that you received?
Yes, ma'am.
Your Honor, may I approach the witness?
Yes.
I'm showing it to Ms. Rivers first. This is going to be State's Exhibit Number 1 for identification purposes. It is a 2-page document. Mr. Roberts, do you recognize this?
Yes, I do.
How is it that you recognize that, sir?
This first form is the Lear Toxicology Services drug testing report received by myself. It was faxed to our office.
The second form?
Second form is the drug testing collection form, which was completed by myself and signed by Mr. Stone.
And are these true and accurate copies of the documents that you received?
Yes, ma'am, they are.
Your Honor, I'd ask the State's Exhibit Number 1 for identification be admitted into evidence.
Objections?
No objection, Your Honor.
And once.
Admitted as one?
Thank you. It was just one, it's a two-page document. And then, so, Mr. Roberts, based on your drug testing, you indicated that it was in fact a positive test?
Yes, ma'am.
And what was that positive test for?
Amphetamine and methamphetamine.
And is that testing positive for those drugs then a direct violation of the rules of community control and probation that he was on?
Yes, ma'am, it is.
Under the guidelines of probation, would that be considered a willful violation?
Yes, ma'am.
And did you also state that he actually did admit after lying that he did use the meth?
Yes, ma'am. The day after he screened positive, he admitted to consuming methamphetamine the morning of the drug screen.
Thank you, Mr. Roberts. Are there any other failures or noncompliance?
Not that I believe I haven't addressed. No, ma'am.
Thank you very much. I'm going to return the documents to Madam Clerk, Your Honor.
I can take a look at them first. Thanks. That's all right.
And I have no further questions for Mr. Roberts, Your Honor. Thank you.
All right. Ms. Rivers, when you're ready.
Mr. Roberts, you had indicated that back when he was in Pensacola that he had failed to charge his GPS monitor?
Yes, ma'am. His RTC device.
Yes. And how do you know that he had failed to charge the monitor?
Upon the initial affidavit filed by Officer Alan Diaz in Pensacola.
And how, again, do you know that that he failed to charge it, though?
It was reflected in his electronic monitoring case notes. He had several documented alarms.
But still, how do you know that he failed to charge it? How do you know that it was something he failed to do and not that it was a result of something wrong with the electronic monitor?
I'm not sure. I was not the responding officer during those incidents.
Okay. Thank you. And would that be the case for each time that it's cited here in this affidavit?
I believe 4 through 8 were pertaining to him charging his device, and to my knowledge, they appear to be duplicative reporting.
All right. And then, once he was transferred to Okaloosa, then you took over being his probation officer?
Yes, ma'am.
And then there wasn't any issue until there became the issue of the scrapyard and the failed drug test, correct?
Correct. He had no issues with his electronic monitoring equipment while he was in Okaloosa County.
All right, thank you.
Any redirect?
Just briefly, Mr. Roberts, as part of your reviewing the rules of community control and the guidelines, did you address the importance of keeping a GPS monitor charged?
That was addressed whenever he was initially instructed on, I believe, January 7th by Senior Officer Jacqueline Johnson, whenever she reviewed his electronic monitoring rules with him.
Thank you very much, sir. Nothing further, Your Honor.
Step down, sir.
Thank you.
Is the witness free to go, or y'all wanted him to stick around?
I believe let's ask him to be held subject to recall, Your Honor.
Any other witnesses, Ms. Bassa?
I'm sorry, no. No other witnesses, Your Honor. Thank you.
All right, Ms. Rivers, any witnesses for your side?
You may have a moment, Your Honor.
Your Honor, my client has indicated that he would like to.
Okay. You can come up here. Scott, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, take a seat there. Make sure you speak into that microphone so we can all hear you. All right, go ahead, Ms. Rivers.
Would you please state your name for the record?
Travis Scott Stone?
And sir, you've heard the testimony here today, correct?
Yes, sir. Yes, ma'am.
All right, and this gentleman who was just speaking, he was your probation officer here in,
Crestview.
right? Who was your probation officer in Escambia?
Diaz.
Okay. And what did you want to tell the court?
The electronic monitoring, I've had plenty, I had a lot of problems with it. I had them changed out a couple times. I had one that died on me, where I had to change it out in Fairfax. When you're sleeping at nighttime, the bracelet gone alarms will go off and clear in the morning. I've had one that in Fairfax, it went completely dead. I'd had that one changed out, so I've had multiple problems with them.
All right.
And being homeless in Pensacola, I didn't really have a place to charge a lot, but it didn't completely die. I was allowed 2 hours here and there.
Okay. Is there anything else you wanted to tell the judge?
No, ma'am.
Since you testified, Ms. Basso gets to ask you some questions.
Yeah.
Also?
I just want to be clear, you did in fact admit to Officer Roberts that you used the methamphetamine, didn't you?
Yes, ma'am.
Nothing further. Thank you, Mr. Stone. Thank you, Your Honor.
Any follow-up on that, Ms. Rivers?
No, Your Honor.
All right, you can take your seat, Mr. Scott. Any other witnesses or evidence, Ms. Rivers?
No, Your Honor. Just argument.
Any rebuttal evidence, Ms. Basso?
No, Your Honor. Thank you. Just argument.
All right. Basso, go ahead with your argument.
Your Honor, we believe we have shown through competent, credible evidence that Mr. Travis Stone was in willful and substantial violation of his community control conditions. The court did hear testimony that he violated the condition regarding the GPS. As the court is well aware, the court may consider hearsay for the purposes of a violation probation hearing, so long as it's not the only evidence that the court is considering. Mr. Roberts did review the information provided by Officer Diaz and was able to explain that there were substantial GPS aways or bracelet gone alerts. Additionally, the court heard evidence that he had been removed from various programs, REAP and Master's Touch, and was then ultimately transferred here to Okaloosa County, where he continued to violate. The most substantial one, really, Your Honor, in the state's eyes at this point is also, along with the GPS, the fact that he tested positive for methamphetamines. It is a test that this officer did personally observe. It was personal knowledge. It was confirmed by Lear Labs, and it is methamphetamine, which of course is a controlled substance. So we believe that is willful and substantial, and we ask the court to find him in violation.
Your Honor, my client has 3 cases that he wishes the court to look at. That's Douglas v. State.
Hold on just a second. Go ahead.
333 Southern 3rd. 353. The next one is Kamoli v. State, and that's 152. Southern Third, 119. That's a second DCA case that is factually similar to this case. And in that case, the court had held that the evidence was insufficient to establish the defendant's failure to abide by the electric monitoring equipment rules constituted a substantial and willful violation because the unit had never completely lost power. Therefore, in that particular case, they alleged that since he didn't damage or remove the device, there was no violation. There is some differences in that case and this case. He also cites Chanel v. State, 200 Southern 3rd, 247. And finally, Selig, S-E-L-I-G, v. State. That's 112 Southern 3rd, 746. And in this particular case, the trial court was said to have erroneously found that the state only had to establish that alerts occurred, and then the defendant's GPS, and then that's all the state had to do to find a violation of probation. The court said that the state failed to offer any evidence as to the cause of the GPS going off, and they didn't offer any evidence that the alerts were the result of the defendant's conduct. Construction, operation, and intentional disregard of the GPS monitoring rules, tampering with the equipment, or actual violations of curfew or other activity or restrictions will generally amount to willful and substantial violations. I asked Officer Roberts when he said about the not having it charged, how do you know? He didn't know. He just says, well, I'm just reading what somebody wrote. How did he know? He doesn't know. So again, you've got hearsay, and you don't know if that was something that there was a problem with the device, whether there was some intentional behavior. It's something that is not known and not proven. So we would argue that when it comes to the ankle monitor and any alerts, that the state has not proven their burden regarding that. And as regard to the other two, we would argue that there's no substantial and willful violations.
Oral argument, Ms. Basso?
Just briefly, as far as the one Covey case that she did cite, in that case, they said it wasn't a violation because in that case, they had never lost power on it, on the GPS. I believe that Officer Roberts did indicate that the notes indicate that it did lose power. For what it's worth, it's just a minor differentiation, but the state does stand by the fact that even if the court sets aside the GPS as a potential questionable violation, even though the state doesn't believe it's questionable, the willful and substantial, taking the drugs, methamphetamines, that's about as willful and substantial as it gets, short of being where children congregate, given his background. So, the state does believe that we have shown.
The other side really brought up any argument regarding the GPS issues about going to Tractor Supply and the scrapyard.
Your Honor, the state believes also that there was evidence of that. That is a violation.
I just want to make sure that wasn't abandoned or I missed something.
No, the state has not abandoned that, Your Honor.
All right, Ms. Rivers, did you want to make any commentary on that? Okay.
No, Your Honor.
All right, well, the evidence as I heard it is, well, I'll just stick with that because we just talked about it, is the GPS showed that he was at those places at a time that he wasn't supposed to be out of his home. I think with these GPS monitors, you can certainly say, well, maybe it was malfunctioning, except for the fact that he had just asked for permission to go to those exact places. And then his GPS showed that he was there, even though he was told he wasn't allowed to go. So I find that to be a violation of his probation. I think it's pretty clear that the evidence of the methamphetamine use, I'll point out, and I don't have the document in front of me, but the cutoff was, I believe, 500 nanograms per milliliter, and the testing showed it to be over 25,000, so over 50 times the cutoff level. So this is not, a small accidental ingestion or being around something. This is a substantial, beyond substantial level of methamphetamine that was shown to be in his urine sample, which was consistent with not only the presumptive or kind of field test that's used, but also with the fact that Mr. Scott admitted to his probation officer that he in fact used methamphetamine. So I think that's kind of pretty clear violation of his community control or probation. And then as far as the issues in Escambia County with the GPS monitor, I believe because Mr. Scott gave some indication that he was having problems with the GPS monitor. Trying to keep this out of my mind, and every other case I've heard where those kind of comments are being made, but because the only evidence of that was basically what the testifying officer said about the Escambia officer, Diaz, and he didn't have any other independent recollection to kind of fill in the gaps there. I'm going to find that he didn't willfully violate his probation by those particular ones, as far as the failure to charge and bracelet gone, because Mr. Stone, I want to call him Mr. Scott, Mr. Stone had given some indication he had had some repeated problems with him, with the GPS monitor. There was no evidence that it had ever been checked out to make sure it was functioning properly. Unfortunately, with the situation of Mr. Stone being homeless at the time, that device was probably susceptible to the elements a little bit more than the average GPS monitor. So I'm not saying it didn't happen, but I certainly can see Mr. Stone's side of that he was having issues with the device. And so that, although it may have not been charged properly, at least that's what it was reporting to the system, I don't find that he willfully failed to charge it, okay, based on his situation as well as being homeless at the time and having limited availability to charge. Anything that I've missed?
No, Your Honor.
How would we like to proceed at this point? Do you want to go forward with sentencing now, Ms. Rivers, or do you want to set it off for another hearing? Do you have a score sheet or anything?
I'll have to just amend it, but it is 79.5 months is what it minimum guidelines.
Today? He would like to go ahead and be sentenced today, Your Honor.
Also, your argument?
Your Honor, based on Mr. Stone's repeated violations, the state would ask that he be sentenced to the minimum guidelines, which, Your Honor, they are 79.5 months DOC, even though the maximum for the third-degree felony be 5 years. As the court is well aware, if the minimum guidelines exceed the maximum for the third-degree felony, then that is what the court must order absent a basis for a downward departure, and we do not believe.
Your Honor, Mr.
Can you get the score sheet together? Have you seen a score sheet, Ms. Rivers?
I can get it, I can just mark it up for now and then get a clean one too.
Well, did you have any objections to it as proffered? She's going to go get the actual copy, but as far as the numbers, have you seen those?
And my client would need to see it.
Yeah, this was the prior one.
You want to take
I
a
can
minute,
go
Ms.
do it right
Rivers?
now.
Well, Ms. Rivers, if you want to show it to your
Yep.
client to make sure there's not any
I
concerns
need for
with
him
it.
to see it.
Yeah, so he's going to be able to answer. It's not going to be done in 5 seconds. But you can take this to him if you want. Okay, so I'll get the plain one. And Your Honor, I did misspeak. It's 79.8 is the minimum guideline.
Did you have 2 prior failure registers? 3.
My original one, right?
Yes, your original one. Says you got 3 failure registers, 1 escape.
And Your Honor, just to be clear, it will reflect the 134.4 points, which comes out to 79.8 months. And that is what I showed Ms. Rivers.
Ms. Rivers, did you have any objection to the score sheet after reviewing it with your client?
No, Your Honor.
Okay. All right, your argument as far as sentence?
Your Honor, my client has battled homelessness, he's battled numerous issues, including addiction. He has wanted help for his addiction. Although you have trouble getting treatment based on your designation, he is asking the court, since that is something you can't get based on your designation, if the court would consider downward departure, 11 months, 29 days.
Under what factor of 921.0026 can there be a downward departure?
Well, ultimately, Your Honor, he would like treatment. However, other than being able to do ECLC out in the community, I don't know of any other drug treatment that he could get in the community, because most will not do treatment with his designation. But I do believe there's a downward departure based on the need for treatment.
Are you citing paragraph M, 2M, which is, talks about treatment-based drug court programs, or are you talking about D, which specifically says unrelated to substance abuse? You have the statute in front of you?
I don't have it in front of me, Your Honor.
I've got a blank score sheet form.
Well, I know. I believe drug court would take him. Well, Your Honor,
And I think the other thing that says that his total sentence points would have to be under 60, which he's not.
I know for drug court, it would have to be 44 to 66. But, Your Honor, there's also the last box that says other reasons that the court can check. And my client is asking the court to consider, based on his circumstances, his homelessness, his designation, his continuous battle, that the court consider 1129.
I'm reading 921.0026, paragraph 3, which says, except as provided in paragraph 2M, which is on the one we just talked about, defendant's substance abuse or addiction, including intoxication at the time of the offense, is not a mitigating factor under subsection D, or subsection 2, and does not under any circumstances justify downward departure from the permissible sentencing range. So if he doesn't fit into that 2M paragraph, which I don't think he does, then I don't think I have really an option to even consider that reason for a downward departure because he's over 60 points. My concern is I heard some things about him being in 2 different programs for which he did not successfully complete them, which would show to me, at least through his actions, that he has not shown that he's amenable to treatment. So I don't think 2M he qualifies for 2M, and therefore I think paragraph 3 controls that says I cannot consider that as the reason for downward departure. So I don't think he's eligible for a downward departure. The score sheet shows 79.8 months, which, as Ms. Basso, you argued, I think, when the minimum score is above the maximum would have been 60 months, that court can go over the maximum, but I think I think I basically have to at this point because of what the guidelines are.
Your Honor, the court must actually, because that is the minimum guideline.
Exactly. So I don't, based on what's been presented, I don't really have any discretion here. So based on that, I'm going to sentence him to the lawfully required sentence, which would be the 79.8 months.
I will get the court the score sheet as soon as I can rewrite it.
I'll give him credit for any time that he served on this case. There's a $100 VOP fee and a $150 public defender fee. Any probation or community control that he had will be revoked and terminated as unsuccessful.
Thank you, Your Honor.
And Mr. Stone, you have 30 days to appeal the court's ruling, the judgment and sentence in this case.
Okay, it's going to take me a minute to write this up. I was going to beforehand, but then I didn't.
Mr., do y'all have things that are going to be quick, or
He was also in the residential treatment.
are they ready to go?
They are, 2 of them are.
Okay, well, I just want to make sure they're fast so we can get to our next hearing.
Signature and done on mine, Your Honor.
Okay.
Well, I don't have. Yes, Your Honor.
Cole? Why don't we bring up Mr. Maddox with Mr. Cole? While we're waiting on him, did you have a chance to talk about Miss Ash?
Some, Your Honor.
It's not if you've come to any sort of agreement on it. She's obviously not here because of.
Yeah, I think what'll probably be best
payments. He wanted to take the deal. I haven't had a chance to go over his rights.
What was the deal for him?
Oh,
I
it's,
Just, it was at incarceration?
Well, but 1 second, Mr.
All right, let's not, then.
When
let's
we
not-
bring it, I'll say what I need to say. Yeah.
I just want to know if it's something we have to do today or not, because I want to make sure we get everything done today.
yes, sir.
No, not in the area, but I got a friend.
Thank you.
Hey,
All
Mr.
right,
McDonald.
we're back to Mr. McDonald.
This is the plea agreement that I went over with you back there. If this is what you want to do, I need to get your signature right there. Oh, the answer is no.
Yeah.
Have a seat, Your Honor.
Yes. Have a good weekend. Well, I guess I'll see you Saturday at first appearance. What's that?
Your Honor, as they prepare, may I bring you that score sheet?
Yes, please. All right, thank you. Yes. You're not coming this week? You get a first appearance like everybody else?
Yeah,
Misdemeanor,
petty
okay,
theft.
just because of the score sheet.
All right, we'll see you Monday. Thank you. Ooh. Uh-huh. What was that? Oh, it fell apart? Didn't spill, did it?
Sounded kind of like an urn. All right, so Judge, we've got a negotiated plea here.
I got myself excused, I was up there.
First degree misdemeanor, petty theft. Theft-related offenses.
Mr. McDonald, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Martin McDonald, January 20th, 1974.
Okay. Mr. McDonald, you're here in 25 CF 1732, charged with felony petty theft, third-degree felony, punishment by up to 5 years in prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that would have you plead no contest to the lesser included offense of first-degree misdemeanor petty theft. In return, adjudication of guilt, 6 months county jail, credit for time served, $270 in court costs, and $100 PD fee. Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
I just signed it.
You don't understand it?
I just signed it.
Did you understand it?
Yes, sir.
Okay. Are you satisfied with your attorney's representation in this case?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Are you, has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand if you enter this plea, there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are listed on page 2 of that document that you signed?
Yes, sir.
And do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. And what is your plea to the lesser included offense of misdemeanor first-degree petty theft?
No contest.
I'll accept your no contest plea. It's freely, voluntarily knowingly given. Adjudicate you guilty. 6 months county jail, credit for time served, $270 in court costs, $100 PD fee. I'll give you 90 days from the date of your release to go pay those fees or set up a payment plan to get those fees paid. All right. I'm going to need your fingerprints because petty theft is an enhanceable offense. And then you have 30 days to appeal the judgment and sentence of the court. Good luck, Mr. McDowell.
Thank you, Judge. Okay, Mr. Johnson, because you've got to make your own way there, You've got 24 hours to report. My understanding from talking with the investigator I sent over to you, Tatum, is that you have somebody available for that.
Where's he going, Mr. Williams?
The Master's Touch.
That Pensacola?
That I don't know.
It is.
I think we just talked about it in the last case, I assumed. but-
It's a transitional housing program in Pensacola.
Pensacola, okay.
Yes.
Because we've talked about it a couple of times today, I just want to make sure location-wise where it is. I hadn't heard about it until today, so.
Here you go. Let me get your signature right there. You can return it that way? Yeah. Sure. Today's 10:30, 10:30:25. Okay.
Mr. Williams, I have a copy of the score sheet. Need one? This is a down departure based on a legitimate uncoerced plea for the reasons we had discussed earlier before he was coming back in.
All right. Mr. Johnson, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Michael Alfred Johnson, 6/21/68.
All right, Mr. Johnson, you're here in 2019 CF 2000. This is a VOP, right?
Yes, Judge.
Okay. It's for a violation of probation with an underlying third-degree felony. Do you understand that? So you're looking at a maximum of 5 years in prison until you accept the plea. You understand that? Okay. I've been handed a plea and sentencing agreement on the VOP that calls for you to admit your violation. The court would reinstate your probation. You'll have to complete your original terms and conditions of your probation, complete the Master's Touch program that we've been talking about today. We've had you up a couple of times already. You have to report there within 24 hours of your release. No alcohol or controlled substances without a prescription. And then a GPS monitor at $1 per day, I'll say that. And then a $100 VOP fee, $150 cost of defense, probation.
I just want to make sure that Your Honor understands that it's not an actual program. It's a transitional housing opportunity, so they don't actually provide services like employment or anything like that. What they do is allow them a place to live for a reasonable amount of rent.
Okay.
So there really technically isn't going to be a program for him to complete.
He wrote program, that's why I said
I
program.
understand.
I appreciate the knowledge on that, because I hadn't heard of the program until this morning.
Yes, sir.
And now it's come across 2 or 3 times, I think, today. All right, is that what you want to do, Mr. Johnson?
Yes, sir.
Okay. Did you go over this plea agreement with your lawyer? Did you understand it? And are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? No? All right. And are you currently suffering from any mental health issues? No. I just need some out loud answers, Mr. Johnson.
I understand the question.
Okay. Well, just, are you having any mental health issues that you're suffering from at this moment?
No.
No. Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
And do you understand by entering admission to your VOP, there won't be a hearing where the state would have to prove that you violated your probation? Okay. And what is your plea? Are you admitting or denying your violation of probation?
Admit.
I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to reinstate you to probation, complete your original terms and conditions, complete Master's Touch. I'm not going to call it a program. Report there within 24 hours of your release. It sounds like you've got a ride there that Mr. Williams has confirmed through his investigator. You're to consume or possess no alcohol, no controlled substances without a prescription, GPS monitor $1 per day, $100 VOP fee, $150 cost of defense that will be kind of put in through your probation as well. I'm going to have you talk to probation before you leave the courtroom this afternoon, and then you have 30 days to appeal the judgment and sentence of the court. I have seen the score sheet. This is a downward departure based on an uncoerced plea agreement and the things that were talked about at the bench earlier.
And if I could just remind Mr. Johnson, he still also has the misdemeanor case going on here. So even though you're living over master's touch, make sure you make your court dates, okay?
Oh, on that, they should have that for you at the jail, but if you have any questions, call Mr. Hall. He represents you on that DUI.
Ma'am?
And Mr. Johnson will remain in jail until GPS is established?
Yes. The GPS monitor has to be put on before you get out of the jail. That may be tomorrow now, so the big thing is you gotta be ready to get over there right away. I'm not sure if they accept people on Saturdays at Master's Touch.
She should be able to accommodate him on
Okay.
a Saturday.
All right.
But I think tomorrow, is tomorrow Friday?
But he won't get out until tomorrow, so, and he's got 24 hours.
Yes, sir.
I don't want him to get out at 9 o'clock tomorrow morning, show up at 9 o'clock Saturday morning, and they say, we can't take you, it's Saturday.
Yes, sir.
That's, and then the other thing, Mr. Johnson, I'm the duty judge this weekend, so if there is an issue with it, they're gonna come to me, and I'm gonna remember that I just talked to you about all this stuff, so make sure you head out there, get there as soon as you can. All right, thank you,
Excuse me,
Mr.
do you-
Johnson.
You want to stay in jail until Monday?
Well, I mean, that way I can,
Right,
met me on
right.
Saturday. I don't want to violate it because, you know what I mean, I try to do.
He's
everything I
concerned
can.
about picking up a violation. He's willing to stay until Monday. Do you want to
Well, see-
sentence him, bring him in and
Can I
sentence him
speak?
on Monday? That would be the only way I could think of to do it.
Can we just amend the plea, yes?
Give him
72
24
hours.
hours within 24 hours to report to Master's Touch within regular business hours, meaning Monday through Friday.
And what I'm going to do is instruct Mr. Johnson to report to our probation office tomorrow morning, and then we'll coordinate with him getting in touch with a probation officer in Pensacola who will set him up a time to be entered.
I guess my concern, though, is if he gets out tomorrow and can't go live there, because he doesn't get there till Saturday,
I don't
where's he gonna live, given his current status?
I don't anticipate that to be a challenge
Okay.
because she would not have offered him the opportunity if she did not have a bed available.
Well, like I said, I'm the duty judge. Call the duty phone, and I'll make sure whatever needs to happen happens from a court standpoint.
Thank you, Judge.
All right.
All right, sir. Good luck.
Thank you, Mr. Johnson. Talk to probation. All right. Mr. Jones, Nathaniel Jones, are y'all ready on that one?
Yep.
Yes, sir. You need a break?
Is that you, Mr. Williams?
It is, Judge.
Okay.
And I would like, well,
Hey, Mr. Jones, come sit over here. Let me shuffle the thing here a little bit, but you're going to be sitting right here. Uh-huh.
yeah. What do I do?
Okay. She is here. Okay. Yeah, she and I have already talked.
Mr. Williams, do you have Marcus Hamilton, too?
Yes, I do, Judge. I thought that we'd discuss that this morning.
You said you were going to bring him back. I was just
Oh,
going
we
to leave
did?
it with Ms. Leone.
Okay.
We still have Hamilton and Hargraves.
Yes, sir. I'm going to say Hamilton then is the priority on it. I think that, though, I don't think anything has happened to change the situation on Hamilton. You've not spoken with, well, you've got Hamilton.
I got Hargraves.
Right. You've got Hargraves, and she's, when I said you, I was pointing, or meaning to point at Ms. Barrickman. I think you made an offer of 24 months. Was that, and he was thinking about it?
Probation or incarceration?
EOC.
It was
Do you want to just
incarceration.
put him on another day? He's not.
If he's not getting out today, I'm not sure if it's a huge deal, so we can just put him on Monday.
Yes, sir. Yes, sir.
That's
fine with
Hamilton.
me.
All right.
I'll add him to my list for this weekend.
Thank you.
And
Your
what
Honor,
about
based
Har?
on that, I don't know anything further, if I could be excused.
Sure.
Thank you.
Saturday morning, 9 o'clock.
8:30, right?
8:30 to review the paperwork if you want to. I always do. That's why I do it that way.
Okay.
I was gonna say, Mr. Williams, for Mr. Hargraves, we don't shouldn't need to bring him out I was notified that he was on probation, so there is a VOP coming.
Oh.
And so I'm not gonna accept any plea right now until I look at the other cases.
Okay, can you?
Same.
Yeah, I'll come see him. You gonna be able to do that by Monday? Hargraves, because they're
It
talking about
depends
putting him
on-
on for then.
Probation has to file the VOP, so I don't know.
What about 12/23 at 9 o'clock? If you want to push it up for any reason, you certainly can.
That's fine.
I just don't have a whole lot of days after next week. The only thing we have left is Mr. Jones.
That's just the inmates.
Let's ask the boss.
They're trying to get him to drug court.
Drug court. I'll be in my notes.
Excuse me, Judge.
We actually put Toller on 12/23.
Yes, sir.
All right, we ready on Mr. Jones?
Judge, we are.
All right, this is 24 CF 1683, State of Florida versus Nathaniel Paul Jones. This is a violation of probation evidentiary hearing, correct?
Yes.
All right, Ms. Leone, are you ready to go forward?
Yes, I'd like to address something. I'm not sure if defense has a witness. If they do, she would
that's-
have to,
Yeah, you want to invoke the rule?
Oh, yeah.
Okay.
Okay, so you have a potential witness?
Yes, sir, I do.
All right. Are you going to be bringing up your witness? You have one witness?
probation officer Junganze, yes,
Okay.
that's all.
All right, your witness is her name?
Sabrina Smith.
All right, Ms. Smith, can you hear me okay from back there? All right, so there's been a rule of procedure invoked called the rule of sequestration, which means witnesses have to sit out in the hallway and not listen to the testimony that goes on, so they don't inadvertently or purposely change their testimony based on what they've heard. I don't think there's anyone out there to try to talk to you about the case, but if anyone tries to talk to you about the case, tell them you can't do that, report that to our court deputies and me when you do come back in. I'm going to send you out now. I'm going to keep the state's witness here because he's going to be called up in just a minute here, so no sense in sending him out. But when he finishes up, we'll send him out, and then you'll be able to come in, assuming there's nothing else after that first witness. All right, thank you, Ms. Smith.
I'm ready to proceed, Your Honor. The state calls probation officer Junganze to the stand.
Why not? And just because I haven't, Mr. Williams, you're ready to go forward at this point?
I am, Judge.
Okay. All right, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, take a seat there. Make sure you speak into that microphone so we can hear you.
Please state your name for the record.
Justin Younghans.
What's your occupation?
I'm a correctional probation senior officer for the Florida Department of Corrections.
How long have you been so employed?
For the Florida Department of Corrections or as a senior officer?
In the Department of Correction, as a probation officer in general?
Nearly 6 years.
Can I ask you a question? Your name again, sir?
Justin Younghans.
Yeah. Can you spell the last name? The clerk
Sure.
is asking.
Sure. Younghans.
Oh, I wouldn't have got the E at the end.
I do it frequently.
Same. All right, go ahead, Ms. Leone.
As part of your employment, do you supervise people?
Yes, ma'am. I supervise people primarily on community control.
And do you supervise Mr. Jones, the defendant in this case?
I did supervise Mr. Jones.
When did you begin that supervision?
Approximately August 8th, 2025.
And do you see Mr. Jones in this courtroom today?
I do.
Can you point to him and identify him by an article of clothing he's wearing?
Right there in the orange jumpsuit.
Let the record reflect that witnesses identified the defendant.
It shall reflect.
Now, has the probation supervisor, community control supervisor for Mr. Jones, do you have care, custody, and control of the file pertaining to that supervision?
I do.
And when did you establish that file?
Beginning August 8th, 2025.
Are you aware whether or not Mr. Jones was on probation prior to you becoming his supervisor?
Yes, he was on a period of supervision before I assumed community control supervision of him.
Now, in the file that you maintain for offenders, in this case for Mr. Jones, are all the notations, records, and documents in the file filled out or completed shortly thereafter the information is obtained?
Yes.
And is there, as part of the file, is there a case log that indicates when certain things are done?
Yes.
Now, you mentioned that you became his supervisor in August
Yes, ma'am.
of this year. And do you know what charges the defendant was on probation for?
May I refer to my notes? I believe he was sentenced to a lesser included offense of attempted aggravated battery.
And does your file indicate whether or not the defendant was advised of the responsibilities and duties of probation?
Yes, so Mr. Jones was instructed on the conditions of community control on August 8th by Officer Aaron Gallagly, and then myself that same day.
And so the day was,
August
when
8th.
was he, the 6th?
August 8th.
August
That's when
8th.
he was instructed on the conditions of
8/8,
community
yes.
control. Yes.
Now, does your file contain the defendant's signature and date that he understood the instructions?
Yes.
And can you please tell the court what were his requirements for probation?
Would you like all of the standard conditions or specifically the conditions?
The
of community
special
control?
conditions
Of community control or just?
of
special
community
conditions
control.
order? Of course, one moment. So the conditions of community control include, you will report to your officer as directed at least one time a week unless you have written consent otherwise. You will remain confined to your approved residence except for 1/2 hour before and after your approved employment, public service work, or any other special activities approved by your officer. And you will maintain an hourly accounting of all your activities on a daily log, which you will submit to your officer on request.
Now, did you have an occasion to file an affidavit for violation of community control?
I did.
And did you apply for a warrant?
I did.
And did you submit both the affidavit, the report, and the warrant to the court?
I did.
And are all the violations that are alleged in the affidavit that you filed?
Yes, ma'am.
And what are the allegations of violation of probation for Mr. Jones?
He has one allegation of failing to remain confined to his approved residence on September 2nd, 2025, and another allegation of failing to provide documentation to me as previously instructed to verify his whereabouts on his community control offender schedule and daily activity log.
Now, what was the date that you said September 2nd?
Yes, ma'am.
Is that about a month after he entered community control?
Approximately.
Now, as part of the special requirements, did he have the requirement to complete substance abuse evaluation and treatment?
I believe he was ordered to complete something called ECLC. I'm unfamiliar with that, being an officer who supervises offenders primarily in Santa Rosa County.
Are you aware if he has ever tried or completed any substance abuse
Judge, I'm gonna
evaluation?
object. This is not part of the warrant. We've not been properly noticed as to this allegation.
Your Honor, this information is contained in the report that was shared in discovery with Mr. Williams.
Judge, I'm not talking about whether or not it was shared in discovery. I'm talking about there's an affidavit and a warrant. The affidavit and the warrant are for the two items that the officer just talked about. The allegation that he failed to remain confined to his residence on September 9th, and that He failed to provide the log on September 3rd. Those are the only two allegations on the affidavit or on the warrant.
Yeah, I believe I can ask him about the conduct of this probationer during the probation period.
Well, it can't be used for purposes of violating his probation. It's not charged.
So I'm going to overrule the objection in that she can ask the questions. However, I agree with you, Mr. Williams, that it can't be the basis of a violation because it's not in the violation section of the affidavit.
Thank you, Judge.
And I'm in agreement with that, Your Honor.
Okay.
Yes. So did he, was also one of the conditions to complete a battery intervention program?
Yes.
To your knowledge, did he complete it?
No.
Did he register for one, to your knowledge?
Not to my knowledge.
Is this defendant's first violation of probation for the case?
No, it is not.
Do you recall when he was originally placed on probation for the case?
I do not recall the original date, but I know that it was sometime this year.
And do you remember when he violated the last time, approximately at least?
I believe it was perhaps in May. I'm unsure exactly.
Very well. Now, what was your recommendation for sentencing for this defendant after you supervised him for about 1 month?
I recommended a period of incarceration at the court's discretion.
And could you please tell the court the reason for that kind of recommendation?
The offender is designated a violent felony offender of special concern, and he has a lengthy criminal history of putting his hands on other people. So I do believe that that, coupled with the fact that he failed to remain confined as approved residence and respect the rule of the court, basically, in community control, that he does pose a significant threat to the community.
Was your recommendation also based on the fact that he was sort of recently...
Section leading.
Rephrase.
Are you, in making that recommendation, did you consider any past violation that he had?
Yes, based on the fact that this is his
Objection
second
leading,
violation.
Judge.
I don't have any other question, Your Honor.
Hold on. Do you want to rephrase the last one? Because I'm sustaining the objection.
No, it's okay, Your Honor.
All right. No other questions? Mr. Williams, Cross?
Yes, Judge. All right. Let's talk, kind of go in reverse order here. Was there a time frame specified in the probation order by which he had to complete BIP?
May I refer to it?
Absolutely.
No, sir.
Was there a time frame in the probation order by which he had to complete ECLC?
No, sir.
Okay. Now let's talk about the let's talk first about this incident on the 2nd. So flesh that out for us. When you went out in your report, it says that you went out and knocked on the door. Is that correct?
First, I attempted to contact the offender at his phone number multiple times.
Okay, so you called his telephone.
Multiple times.
All right. And then did you go physically out to the house?
Yeah, I was already at the house, sir.
Okay. And did you knock on the door?
Multiple times, yes, sir.
All right. Did you look through any windows?
It's always quite dark in the house because Mr. Jones's residence sometimes has power and sometimes doesn't. To my knowledge, at that point, it did not have power. I always attempt to peer in the windows, and I could not see anything.
All right. What windows did you peer in?
The front window.
What rooms?
The door, the front door into the living room, kitchen area, the entryway.
Okay. So not any bedrooms?
If you saw the property, sir, you would realize that it'd be very difficult to actually get to a bedroom window.
Okay. All right. So you were not able to look through a bedroom window?
No,
and
sir, I was
therefore did
unable to
not-
look through a bedroom window.
And therefore did not look at in a bedroom window?
Correct, sir.
All right. Now, let's talk about the log. The log that you're, well, let me ask you this. When was, is this something that he's supposed to do every day? He gives you a log of, I woke up at such and such a time, I ate breakfast, or is it just where he leaves the house? What's the situation on the log? How's that supposed to work?
So the way the community control works is that each week, the offenders will report to the probation office, and they'll complete what's called a community control offender schedule and daily activity log, which will contain their movements, their whereabouts, and their hours every hour of the day, every day, until the next time they report to the office to submit a new schedule. It does not, it's not like wake up at this time, et cetera, no, sir.
All right, so is this based on the approved activities for that day?
What's your question?
Is the log, the daily log, let me parse it out a little bit more. Does he do a separate log for each day?
No, sir.
Okay. And is the log based on his approved activities for that, I guess, that time frame then, that week?
So the only thing that should be on those logs are his whereabouts and his approved activities for the week.
Okay. And this would be based on the approved activities that were discussed with his weekly meeting with the community control officer?
Yes, with me.
Okay. And so what were his approved activities for September 3rd?
I believe the violation is on September 2nd.
All right, so because your second condition says failed to provide the officer with documentation to verify his approved activities on September 3rd. Is that just the date he was supposed to turn it in to you?
Yes, sir.
All right, so what you're talking about is when you went out to the house, one violation condition is that you believe he was not home. The next is he did not provide you a log saying where he was on that day.
No, sir, it's not that he didn't provide me a log. The actual allegation says that he did not provide me documentation to verify any approved activities. So community control offenders are typically instructed to bring their community control officer receipts or documentation to verify their approved activities during the previous week, and he failed to bring me any documentation to verify his activities during the previous week.
Well, if his activity is going to work and coming home.
Mr. Jones wasn't working.
Okay. So what were his activities that he failed to provide documentation for? What I'm trying to discover here is it something for which there would be documentation?
Mr. Jones at that week had a approved stop at the Lakeview of Avalon Center and the UPS store.
Okay, so if he didn't buy anything at the store, would he have a receipt to provide you?
Why would he go there if he didn't buy anything?
So you've never gone to the store and they didn't have what you were looking for?
Not the UPS store, but no, sir, I mean, offenders are instructed to bring us some sort of verification, no matter what it is, to have an employee write their signature, so-and-so was here on this day and time, sign it, something. They're all instructed to bring us something to verify their whereabouts.
And during the time period that, well, never mind. Was this the only time that he failed to provide you with that documentation that you're requesting?
To my knowledge, yes.
All right, and did you ask him why he didn't give you that documentation?
I did.
All right, and what did he say?
I believe he said he must have left them at the house, as a quote.
When he came in to meet with you, he left it at the house?
Yes.
Was there any discussion about him going and retrieving it and bringing it to you?
I do not recall.
I don't have any further questions, Judge.
Just
Direct.
a couple questions. Officer, how did you knock on the door?
Typically, when I first knock on a door, it's very regular with knuckles rapping on the door, and if I don't receive a response after a few minutes, I will knock with the side of my fist quite loudly.
And did you have a chance in the past to visit the interior of the residence?
I have, yes. I performed a walkthrough visual inspection.
Now, you did describe the interior in your report. Why did you describe it?
Because at my previous visual walkthrough inspection, the house, besides being in a very filthy state, It had very, very little furniture. And I recall walking through the house and speaking to Mr. Jones and our voices echoing over the walls. So at the time when I was knocking on the door, I distinctly recall my knocks echoing through the house, meaning if someone were inside the home, they reasonably should have heard me and responded to the door.
When you spoke with the defendant about this particular incident, what did he tell you?
I believe he told me he was sleeping despite it being approximately 7 p.m. And I believe he told me that his girlfriend had heard me and did not answer the door for whatever reason.
Have you, before this incident or during your supervision, had you ever met the defendant's girlfriend?
No, I have not actually.
About the log you were discussing with Mr. Williams, by that time, had he provided you with either log or receipts or evidence of where he had been in the past weeks?
Yes, so each week they're instructed to bring us back the previous community control offender schedule and daily activity log, and like I said, any documentation to verify their whereabouts for the previous week at any approved stops. So he had brought me verification in the past.
So in other words, he knew that he had to do that every week?
He did.
It's your opinion that this defendant intentionally and willfully violated the terms of his probation?
Yes, I do not believe that he was home at the time of my attempted personal contact, and I believe he was well aware he was instructed to bring me documentation and failed to do so for whatever reason.
Now, what was the date? Is September 3rd the date that he came to your office?
Yes.
And was that the date he was supposed to bring the log or evidence of activity for the prior day or so?
Yes, his schedule and his documentation for the previous week.
Thank you. No other questions? As far as I'm concerned, he can be released.
Mr. Williams, do you want
No,
to?
Judge, I'm not in a position to ask him further questions.
You're free to go. You're also free to stay.
Thanks.
Any other witnesses?
Not from the state, Your Honor.
Mr. Williams?
Judge, violations of probation or community control have to be both willful and substantial. The testimony from the officer was that he simply forgot it. There was no discussion about him going back and getting it and returning it. He said that he left it at the house. So with regard to the second one, I'm going to argue that's not willful and ask the court essentially to JOA it. I'll put on a case if the court denies it. With regard to condition one, there was no verification that, for example, the defendant was and his girlfriend were not simply asleep in one of the bedrooms within the area and didn't wake up.
There's no evidence that they were.
Not yet, Judge. This is
So
my
at this point-
JOA on it.
At this point, I'm denying your request.
Yes, sir. In that case, I'll present a case, Judge. Judge, I'm going to first call Sabrina Smith.
All right, Ms. Smith? Raise your right hand. Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth? Take a seat. Make sure you speak into that microphone so we can all hear you. Go ahead with your questions, Mr. Williams.
Thank you, Judge. Please state your name for the record.
Sabrina Noel Smith.
All right. Ms. Smith, what's your relationship to Mr. Jones?
He's my boyfriend.
Okay. Do y'all reside together?
Yes, we do.
All righty. Let me draw your attention back to September 2nd of 2025, approximately 7 in the evening. All right? What had you and Mr. Jones been doing immediately prior to that?
We were playing Monopoly.
Okay. And what did you do after you finished playing Monopoly?
We went to sleep.
All right. Where did you go to sleep?
It used to be my old spare bedroom, but now it's the bedroom we sleep in.
All righty. Did you hear anybody knocking on the door?
I did.
Okay. What did you do about that?
I, at first didn't think much of it, but I tried waking up Nathaniel.
All right. Did you know who was knocking?
No, I did not.
All right. And why did you decide to try to wake up Nathaniel instead of you going to the door?
I knew he was on probation, so I wanted to wake him up in case it was his probation officer.
Okay. Were you able to wake him up?
I was not.
All right. And did you hear any phone calls?
I did not.
Okay. When you could not wake him up, what did you do?
I just went back to bed.
All righty. Why did you not go to the door?
I had just been released from the hospital with a blood clot in my leg, so it was very painful for me to get up and walk. So.
Okay. Now, there's also an allegation that he was supposed to fill out a log of his daily activities and turn it in. Do you know anything about that?
I did not.
Okay. Let me ask you this. Did you have a vehicle at the time?
I do.
Where was the vehicle parked?
In the driveway.
Visible?
Yes.
From the front of the house? Did he have a separate vehicle?
No.
Okay. Would he have been using your vehicle if he went someplace?
Yes.
Okay. Was that normally the vehicle he would use?
Yes.
All right. I don't have anything further, Judge.
Awesome, Ms. Leone.
Good afternoon, ma'am.
Afternoon.
You're aware that your boyfriend violated probation back in June or May?
I am.
And you're saying that you heard the knocking on the door, correct?
Yes.
How about Mr. Jones' phones? It rang, didn't it?
I don't know. He has his phone on silent.
And you didn't think it was important for him to wake up if it was his probation officer outside?
I thought it was important, so that's why I tried to wake him up.
And what time was that?
I believe around 7, it was dark outside, so.
Do you guys go to sleep early at night?
For me, I have diagnosed insomnia, so whenever I can sleep, I will go to sleep. But, yeah, some days we'll go to sleep that early, some days at 9 o'clock.
Now, you drove the defendant to the UPS store?
Yes.
And why did you go there?
To drop him off.
At the UPS store?
Yes.
What do you mean by that?
He had an interview.
And did you also drop him off at the Avalon Center?
No. That's where I go.
And he takes you there?
No, he just went with me.
At the UPS store, you went there, you said for what?
An interview.
Was he interviewed?
Yes.
When you went back at the house, did you see any paperwork for that interview?
I don't believe so.
No other questions?
Is there any reason why you would have looked for the paperwork?
No.
Is there any reason why you would have tried to locate the paperwork?
No, usually he told me they're just going to call if they have a second interview, so.
Okay. So is there anything of your knowledge that would dispute or disprove that he had simply left his verification at home?
What do you mean?
Objection, Your Honor, calls for speculation.
I'm I'm asking if she has any evidence to disprove that. The state pointed out that she didn't, or asked her questions about the paperwork. I simply asked her originally if she knew anything about it.
Overruled.
So is there anything that you know that would disprove that he just simply forgot to bring it with him that time?
I wouldn't know. I don't keep up with his paperwork.
Okay. All right, that's all the questions that I have of this witness.
This witness be excused.
Yes.
Judge, actually, I'm going to ask her to stick around for just a minute. I'm going to recall the officer.
Okay, well, ma'am, you're going to have to take your seat back out in the hallway. I'll point out, I asked if anyone was going to ask any more questions to the probation officer. Y'all both said he could be released, and he's been in the room the entire time. Ma'am, you're.
So,
you can-
hallway?
Hallway, yes.
Okay, thank you.
Yes, sir,
Fine with that.
I understand. It's just something that I didn't know was going to be important until after she testified.
You don't have an issue with it? I don't have an issue with it.
No, I don't have an issue.
I just want to make sure it's on the record that he was able to listen to the testimony of Ms. Smith.
Yes, sir.
Reminder, you're still under oath.
How many vehicles, oh, I'm sorry, let me let you get situated. How many vehicles are available to Mr. Jones, do you know?
I do not know, sir.
You remember how many vehicles were there when you went and knocked on the door?
No, sir, I don't recall.
Okay, I don't have any further questions.
One question. Have you ever seen any cars at his house?
I do recall at least there being one vehicle. I do not know how many. I mean, I know that he has reliable transportation to the probation office.
Was a vehicle present at the time on September 2nd?
I do not recall.
The Avalon, that's Lakeview of Avalon.
Yes, ma'am.
Why did he have permission to go there?
Yes, he should have been seeking his own treatment.
At that Lakeview?
Yes, it's Lakeview of Avalon Center. They're a treatment provider in Santa Rosa County for mental health issues, substance abuse issues, et cetera.
So it's your understanding that he was going to the Avalon Center for himself?
Yes.
And did he tell you why he went to the UPS store?
I don't recall that, no.
Was he looking for employment at the time?
Judge. Objection.
He was ordered to job
Hold on a
search.
second.
And also leading. She previously
All right,
asked.
I'm
him-
sorry, overruled on both grounds. Go ahead.
Did you give him permission to go to the UPS store?
Yes.
If you recall, do you remember the time that he was allowed to go to the UPS store?
I do not recall right now, no.
But when you give permission, do they have to give, do offenders in general have to give you a time frame?
Yes. There's a specific time at which they're approved to be there.
Thank you. No other questions?
Anything else, Mr. Williams?
You indicated that the Avalon Center was where he went.
Yes.
Okay. Are you aware that they might each have different appointments?
I do not know her whereabouts or activities, no.
You're not, you have no need to be privy to that. She's
Right.
not on community control, right?
Right.
Okay. So you don't know whether he was there as an approved with her, if he was there also for himself. You don't know which of the
Well, I would not.
various permutations this was.
I would not approve someone to go to someone else's treatment.
Okay. I don't have anything further then, Judge.
You can take your seat again, sir.
Thank you.
Any other witnesses, Mr. Williams?
Judge, I'm going to recall her and ask her about the visit, and if she knows whether or not what he was doing while she was in her therapy session, whether or not he was having his own.
No, she answered that question clearly.
No, she didn't. She
Well,
answered.
hold on
it.
a second. For what day are we talking about?
This would be whichever occasion that the state was asking, well, I guess it would be on, I guess it'd be for the visit the week of that he was supposed to turn it in on the 3rd, because the state had asked her, if she was there for his appointment or for her appointment. And she said she was there for her appointment. We're kind of going down a rabbit trail maybe we don't need to go down.
He was allowed by his officer to go to Lakeview. Right?
Yes, sir.
Whether or not they went to Lakeview, the violation that's, you're talking about the one of not providing the documentation to show that he went there.
Yes, sir.
And she, I believe, testified that he did go. Now, whether or not he lied to his officer by going to her appointment instead of his own, that's not what he's accused of.
Yes,
I
sir.
don't understand how it's relevant.
I'm not going to, I'll withdraw it then, Judge.
Anything else?
Nothing further. Well, give me just one moment. Judge, I just wanted to inquire the defendant whether or not he wanted to take the stand. I've explained to him that it's a him decision. I don't know that he necessarily needs to, but he would like to.
All right, come on up, Mr. Jones. Raise your right hand. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth? Go ahead and take your seat. Make sure you're speaking to the microphone.
Yes, sir.
Are there any questions, Mr. Williams?
Hair closer to him, so I don't have to yell too much.
Well, if you speaking to the microphone, it shouldn't be a problem.
Yes, sir. All right. Please state your name for the record.
Nathaniel Paul Jones.
All right, Mr. Jones, you're aware of the allegations. With regard to whether or not you were at home on September 2nd at around 7 p.m. in the evening, tell the judge.
I mean, I was at home. I wake up pretty early, about 4 o'clock. We'd been busy throughout the whole day at the house kind of thing. We just fall asleep early sometimes.
Did you hear the knocks?
I did not.
Did you hear your cell phone going off?
I did not.
Do you normally have the ringer on?
Yes, sometimes, but not all the time.
When did you discover that, well, let me ask you this, did you get woken up by Ms. Smith?
It was about 10 minutes after I eventually did wake up, and then I saw the missed calls, and I asked her if she had any missed calls or anything like that, and she said no.
Now, why would you ask her if she has missed calls?
She was the emergency backup number in case I wasn't able to get a hold of I thought that he would have called her number as well. That's why I asked that. I did call him back about 10 minutes after the timestamp of the calls. And he answered, but they weren't going to turn around or anything, but
Or you say he wasn't going to turn around or anything?
I guess they had already left the house.
They?
Oh, the probation officer.
Okay. And did it come up with him, the possibility of, going ahead and coming back and seeing that you were there? Tell us about the conversation.
They said that they weren't able to get a hold of me and he would let the courts know. And I asked him if, I don't know if I asked him or not, but he basically said that they weren't going to turn around to come check after that.
Okay. All right, so tell us about the log. Was it the next day that you were supposed to turn in some kind of log?
It was every Wednesday I was supposed to be up there, so if that day was a Wednesday, then yes. Yes.
Okay. And so tell us what happened with not turning in the log.
Either I must have left it at the house, or because I thought I had all the paperwork, I probably grabbed some blank ones or some old ones I had filled out, because I would bring extras home to fill them out ahead of time. But there's no reason I wouldn't have filled one out at the office. I wouldn't have just not turned one in,
All right, now tell us about filling it out at the office. How does that work?
They have like a stack of papers up there, and some people, when they go up there, they just fill them out up there while they're waiting in the lobby.
Is this something that you're seeing while you're waiting in the lobby?
Oh, yes, sir.
Okay.
That's kind of the whole reason of going up there, is to turn in the schedule. So it wouldn't make sense to be up there without one or not turning one in at all.
All right, so so what is your recollection as to what happened on the 3rd, when it's alleged that you did not turn in the verification?
Well, she didn't get any, she had a...
When you say she, we don't know who you're talking
Sabrina,
about.
she had a card for the person's name of the Avalon Center, but it wasn't like any paperwork or whatever. And I think I was told I need something more than that, than just like a business card type thing.
Okay. What was the interview that you had at UPS?
Oh, it was a job interview.
Okay. And was there any paperwork given to you at the close of the interview?
No, it was just the first interview to go in there and meet and everything.
Had you been to job interviews before while on community control?
I don't think so, no.
Okay.
I think that was my first one since I was out.
Had you been told specifically what kind of proof to bring when you went to a job interview?
I mean, there's just general documentation of things like doctor's appointments and things like that.
Okay. All right, so did you tell the officer that you had forgotten and left it at home?
Left what at home, sir?
The log, verification.
I mean, I believe so, yes.
All right. And was there any discussion about you going ahead and going home, picking it up, and coming back?
I would have just filled another one out while I was up there. It wouldn't make sense to go all the way, because it's about 45 minutes from, I'm over in Navarre, and it's Milton, where the probation office is.
Do you remember specifically what the discussion was about the missing log?
Not specifically, no. I mean, but I would have filled one out there, because there was a stack of blank ones up there to fill out.
All right, so just to make sure that we all understand what you're saying. What you're saying is that if you had left it at home, as the officer testified that you did, okay, you said you'd just simply forgotten it, you would have filled something else out there at the probation office?
Yes, sir.
And you don't remember whether there was any discussion about your going home to get it, just like the officer didn't remember?
Well, it wouldn't have made sense to do that, so most likely not, but I can't recall for sure.
Okay, all right, I don't have anything further.
Yes, follow-up question. Mr. Williams? Mr. Jones, you never went to Lakeview, right?
We went together, me and Sabrina.
And you went because of your girlfriend, correct?
She had an appointment, yes.
But you asked permission to go for yourself, correct?
No, because I had to go up there, and I told him that I was told by Officer Younghands, well, you might as well make an appointment up there for yourself as well. But I didn't do that because we had to.
But you didn't have permission to just drive your girlfriend around, correct?
He knew I was going up there, so yes, ma'am.
But you didn't go for yourself?
No, ma'am.
You were ordered to do substance abuse evaluation and treatment, correct?
Yes, ma'am.
And you were ordered to be doing the battery intervention program, correct?
Yes, ma'am.
Now, when you violated probation, do you remember in May of this year?
Yes.
And you admitted that you violated probation?
Yes.
And one of those admissions, you admitted that you submitted a false report and also answered untruthfully.
Objection relevance.
Impeachment on the defendant?
Overruled.
Go ahead. You admitted that you were untruthful, correct?
I mean, could you repeat it? Please?
Yes, sir. One of your prior violations of probation were based on failure to answer inquiries truthfully. And you admitted that you violated the condition, correct?
That's what it said, then yes.
No other questions?
Any redirect?
Seems kind of a silly and obvious question to ask, but are you lying about anything today?
No, sir.
Okay, thank you.
You can take your seat, sir.
Yes, sir.
Anything else, Mr. Williams?
No, Your Honor.
Not from the state, just argument, Your Honor.
All right, go ahead with your argument, Ms. Leone.
Yes, Your Honor. As this court very well knows, based on the court's file, and actually was Your Honor who accepted the plea agreement back in January 6th, 2025, he pled to attempted aggravated battery with great bodily harm as a negotiated plea. At that time of the plea, he already scored 54.8 points, so it was the first downward departure that he was afforded. He was then placed on probation. He was to serve a 3-year term of probation, and he violated the first time in May, so therefore only after 4 to 5 months. At the time, probation officer recommended revocation. However, he was given an additional chance, this time with a more stricter type of supervision, and that was community control. He was instructed on all the terms. He knew exactly the conditions that he had to follow. He had to allow a probation officer to visit the home, and he had to seek permission every time he would leave the house. The officer said that he was supposed to complete a substance abuse evaluation and also the battery intervention program, although there is no deadline for the enrollment. What I'm presenting to the court is that he had those conditions from the first time he got on probation, from January 6, 2025, and obviously, as we have realized today, he never did. He also, officer said that they can seek permission to go, obviously, to the treatment center because they're being ordered to do that. And we've heard from the testimony of his girlfriend, who was very genuine when she answered the question, oh, no, that's where I go. He wasn't going there for himself, and he also admitted that. As far as the UPS story is concerned, he should have had whatever receipt or evidence, and he knew he needed that. He knew he had violated probation just a month prior to this, because this is extremely important, Your Honor. He pled to the VOP on this August 7, 2025. Less than a month after he pled, he committed this violation. Probation officer testified that he had visited the house, he noticed that there were much furniture in it, and he could hear his own knock on the door in the whole house. It seems a little bit disingenuous to think that this defendant was sleeping so deeply at 7 p.m., not having an employment, and his girlfriend trying to wake him up, and she couldn't wake him up no matter what, although it was so important. And she knew she's been the victim in the original case. She's been the girlfriend since. So she knew he was on probation, and how important she testified that he would answer the probation officer. But conveniently, he was asleep so deeply that he couldn't be woken up. And then conveniently, when the following day, he goes to the probation office for his check-ins and deliver the evidence of the stops that he's made prior, he does not have that documentation. He doesn't have the Lakeview Avalon Center documentation. He doesn't have the UPS store where he said he went, probably to seek employment. Your Honor, this defendant knew exactly what he was doing. He lied the other time, during the other time of supervision. He's lying today. The officer has testified that there's no way that a person would not have heard them knocking on the door and then calling repeatedly. This is a willful violation, is intentional, is not a mistake. And, again, it was a downward departure the first time, was a downward departure the second time that we allowed him to be on probation, and he's not obviously taking it seriously. He's a violent felony offender of special concern. So there is a big concern for the safety of the community and the fact that he's not able to respect even the minimum requirements of probation. The standard, of course, is preponderance of the evidence, and the state asked the court to find Mr. Jones that he's violated probation willfully and materially.
All right, before Mr. Williams argues, Ms. Leone, I looked up the case, and as far as the guidelines, the ones that I'm showing from January 6th, because of the reduction in charge, I'm showing is only 36.8 points.
No, Your Honor, there were also this is the score sheet I have, and there are the 18 points for the victim injury.
Those are crossed off on the one that's filed. What I'm saying is I don't think it was a downward departure, at least not that time. And I can't find any other guidelines from when he pled in August.
Your Honor, if I may, the minute sheet shows that it was a downward departure the first time he pled. Let me see, I'm looking at 1-6.
If I may, while she's looking, if it was an attempted, that may be why no victim injury points were scored.
That's what I'm showing. I've got aggravated battery, then that's crossed off as attempted aggravated battery, which knocked it from a level 7 to a 6, changed the points from 56 to 36. The 18 for victim injury points is crossed off. And then there's 0.8 points for prior record, which is where you get the 36.8. The 74.8 is crossed off to get to 36.8, again indicating that the 18 for victim injury were taken off and the reduction from 56 to 36.
Yes, sir.
On page 2, it's all similar. Everything goes down to 36.8 points, which doesn't score.
My recollection, too, is that last time we had a discussion about the attempted battery and that versus assault. So it does ring a bell with me, Judge. I think the court's memory is correct.
Well, it's not my memory as much as I'm reading what's been filed, the court file. And then when I get to the the May VOP.
Yeah, that's your Honor, where I read that it states that it was a downward departure at that time.
And I see that's written in the clerk's minutes
Yep.
for the August 8th, or August 7th. But I don't see any guidelines. And I guess I'm wondering why, if it was 36.8, and you had a technical violation, right? Which would have added 6. You would have been at 42.8, right? Why that would have been a downward departure.
I didn't write that. I don't know, Your Honor, why it was there, but I want to present to the court an argument that the victim injury points can be added at any time.
What was filed, they were crossed off.
I understand, but we can add them at any time there is a sentencing. That's the statute.
But no guidelines have since been filed. That's what I don't see any guidelines after the January guidelines.
The guidelines that I'm arguing about today, they have the 18 points plus the 12 points for the 2 violations.
Your argument up to this point has been he's got 2 downward departures already, and I just don't see where that's happened. Again, I'm asking because I want to make sure I'm not missing something.
I'm going to check benchmark, Your Honor. Now I'm looking at the clerk, the new,
Odyssey.
yeah. I don't know if that's the guidelines that were filed at the time, last time, at the last violation. Yeah, they are on benchmark. And the 18 points for victim injury were there.
What date is that?
That is the 7th of August? Yes, yes. Yes, 8/7/25 on benchmark.
There a docket line number next to it?
Docket line 114.
I'm just showing that as my 114 are the clerk's minutes.
Why is it, may I approach?
Sure.
With my computer, or I can show it. Mr. William.
Guess I can try benchmark. I thought we were past benchmark at this point.
Oh, you were not looking at?
I was looking at Odyssey.
No, I was talking about 114 in benchmark.
Okay, let me try that one.
Oh, sorry, I wasn't clear. Yeah.
Well, it shouldn't be different. What's that? 00, what is this number?
Yeah, but it's an F3L6.
Well, here's the problem, though, that's not what he pledged to originally.
It's still the same points, point purposes, but wasn't an objection to it either. Otherwise, we would have discussed it, but. I can see them now. I looked in 2 different other places and they weren't there. So they're in benchmark, they're not in smart bench, they're not in Odyssey. All right, I'm sorry, Mr. Williams, I interrupted before you had your chance to argue.
I wasn't sure if we were still on her argument.
Now that I see that they're actually there,
Well, I don't,
we're looking into a third system to find things that should be in the court file.
I generally look at the question of guilt or innocence first and then sentencing. I will say that if it's, whether or not I objected to it last time, if it's an attempted battery, how can there be victim injury points? And so those should not have been scored, and I would object to them being scored. But the violations have to be both willful and substantial. The officer did not look in any bedrooms. There's nothing that the officer can testify to that directly contradicts the testimony that the court heard today from Ms. Smith. Ms. Smith is not charged here. No impeachment evidence is provided with regard to Ms. Smith, and again, nothing that the officer testified about contradicts her testimony. So I'm going to argue, Judge, now as it happens, the defendant has testified as well. The testimony is simply that he didn't wake up. She tried to wake him up and could not wake him up. She testified that she did not go to the door because she had blood clots and it was painful for her to walk, which might explain why it would be necessary for Mr. Jones to drive her to her appointment at Avalon, because driving requires the use of her legs. And that may explain why he also said, I never would have, but if there was a reason for it, the officer very well may have approved it. He didn't have a direct recollection as to whether or not he did. With regard to the count 2, the officer testified that the defendant simply said that he forgot. He did not recall whether or not there was any discussion about him going home and getting it and bringing it back. The defendant testified that he didn't have a clear recollection of what happened on that day. So I'm going to argue that that one's not proved as well. And certainly the willfulness of it is not proved if he simply forgot it. Same thing with the count 1. The willfulness is not proved if he simply failed to wake up. That's not willful. There's no evidence to contradict that. So, Judge, I'm going to argue that the violation of probation is not proved. And then if the court disagrees with me and holds that it is, then we can talk about sentencing, whether or not those points should be included.
You don't need anything else?
Just to point out that he did not have permission to drive his girlfriend around from probation. He was supposed to go there for himself, and he didn't go for himself. That's all.
Well, I guess that's the situation, though. There's no allegation in the VOP affidavit or warrant that he lied to his officer in order to get permission to go somewhere, or that he went somewhere he wasn't supposed to for whatever reason. It's simply that he wasn't home during the 10 minutes of knocking, and that he didn't provide any proof of where he had been. As far as the proof of where he had been, what I've heard is that he was at Avalon, and his own testimony was he drove her, so he wouldn't have received anything as far as paperwork to prove he was there. And it was the UPS store. There's a question about, well, did he buy anything? Did he have a receipt? Where his testimony was that he was there for a job interview, so there wouldn't be a receipt to that. So I don't see that as a violation given what I've heard today. As far as him not being home, honestly, I keep kind of wavering back and forth on what I think about the situation. It's plausible that both people were home and asleep. I think what matters to me is that they called within 10 minutes. This is not a situation where he reported the next day and they're like, where were you yesterday? It's like, oh, I was asleep. So that's when we start getting into substantial. Even, I mean, it is a pretty low burden of preponderance. And I'm kind of wavering back and forth. I think there's certainly concerns that, especially based on his history, in this case alone, that he doesn't feel the need to tell the truth to his CC officer or probation officer. But that's not what we're here for. That's not the affidavit. That's not the warrant. But the way I see the evidence is, I don't think, based on what the officer testified to, that if he had said, I need to drive my girlfriend to Avalon for her stuff, that he would have approved it. And so I think I found that story not credible. I don't think he asked to drive his girlfriend there as far to get approval for it. That may be what he ultimately did, and I think he testified that's what he did. But so I think it's, his testimony wasn't credible. But again, that's not the charge at this point. So I can't find that he's violated his probation on something that especially because Mr. Williams did object early on in the beginning, saying that these are the only two things, so we don't want any issues to come in. And I said I would let it come in for purposes of setting the context, basically, but I can't find him to have violated if he wasn't charged with that, basically. So what I'm going to find as far as the not being home is that I can't say for sure that that's what happened. And it's a preponderance, so that's why if this was a beyond all reasonable doubt situation, it's pretty easy. I don't think the state can prove it. It's preponderance, and that's where I'm still kind of wavering. Given the situation, I don't think the state's proven by a preponderance that's a substantial violation because of the call 10 minutes later. I think it's plausible, and I don't think I should be, I know what everyone's saying. You talk about sentencing after you talk about guilt or innocence or violation, but I just don't think this is a substantial enough violation to get to this point. However, Mr. Jones, I think putting you back on probation or CC is just, we're almost going to be waiting for the next violation based on what I've seen up to this point, because I think you violated your CC by something else that just wasn't charged, because I don't think everyone knew the facts of what came out today until it came out of the testimony. And I'm not saying that the state or probation, should have filed it this way, because I don't think they knew it until it all came out in the hearing today. So, I'm going to find you haven't violated your probation. However, I think, unfortunately, I think we're going to see you back sooner than later, unless you start living right and doing these things. You've been on probation or community control since January, and you've virtually done nothing that you're supposed to accomplish. If you had signed up for batter's intervention that first month, you'd be done.
Listen to him.
So I don't have really another choice based on my ruling. Is I don't think it was a substantial enough violation on the 10 minutes, because there's a plausible explanation. Doesn't mean I necessarily believe it, but I think it's plausible enough that I can find it wasn't substantial. Again, if he had called 2 hours later or the next day and said, hey, I'm here, were you here? Then I think maybe that's substantial enough, because too much time has gone by. But because it was only 10 minutes, I think it's not substantial enough for a violation. I mean, I don't think the state has done anything wrong here. I don't think the probation officers have done anything wrong here. It's a borderline call, and frankly, when I'm not quite sure, I think I have to go the way of finding someone either, well, that they haven't violated their probation, even with a preponderance standard. But I hope I don't see you back here, Mr. Jones. But based on your behavior up to this point, I'm concerned. And I think in addition to the fact that you admitted to violating your probation previously by lying, and now I think you've lied to your probation officer in order to get the approval, based on what I've heard today, it's something that's going to be, I'm sure, looked upon with intense scrutiny going forward. Anything else?
Not from the state, Your Honor.
All right.
Not from the defense, Your
You're still on your community control, Mr. Jones. You're going to have to talk to the officer here. Obviously, your actual officer, I'm not sure if you're still going to be the officer, is going to be there, but they're going to give you your reporting instructions. And I would suggest, and when I say suggest, I'm telling you, do what I've already ordered you to do twice. Go sign up for your counseling, get it done, keep looking for work, and get out of this, whatever rut it is that you're in, because it's time to move on and start doing things the right way. And again, look at your 36 years old. Time to get there. Anything else?
Nothing from us, Your Honor.
No, nothing.
There's nothing, is there anything else holding him?
That'll just be reinstated under the original terms and conditions.
Yes. If there's nothing else holding him, I'm assuming he's going to be released.
Thank you, Your Honor.
Thank you.
Do we have anything else?
I'm going to get home before 11 or 11:30 for the first time in over a week.
I know you said that before. I just do my work from home, and I usually have been doing it till 9, 10 o'clock or more every night. Certainly this week.
Yes, sir.
All right. Well, I appreciate y'all being here and taking the time. I know it's been a long day for everybody that's involved. But I have to go home and read for civil now.
Now I have.
It's nice. I'm everything they want me to read for civil has just come in while we've been sitting here this afternoon. Yeah. Honestly, I think I was having this conversation with someone earlier today. Might be time for me to start canceling hearings if they don't want to send me things in advance so I can read it and not have to do it until 11 o'clock at night. Well, what I've done up to this point is say I'll read it after the hearing because I didn't have time to, but then it puts it on me to read it all and come up with a decision. And so it's just, at some point I've got to, I would say put myself first, but put getting the job done first as opposed to letting people get away with this stuff. All right, we're adjourned. We will see you on Monday.
Monday, yes, Your Honor.
I'll be here in the morning, but you won't, right? But I'll be in the office on Zoom.
All right.